ये सब देख करके जो क्रॉस केस है मैं एनडी प्रजापति આવે વકીલ પત્ર મોકલાવ્યું છે તેનો क्रॉस केस આ કોણ સાહેબ એક જ આવું છે એટલે
नहीं साहब आमा मंगलबुध में अपन साहब मने પછી સાહેબ સાથે કરી દઈશું जी सर आरोपीओનો રિપોર્ટ આપો સાહેબ
વકીલ શ્રી બીબી પટેલ વકીલ શ્રી બીબી પટેલ વકીલ શ્રી આને અબુરા વકીલ શ્રી આને અબુરા વકીલ શ્રી કે ગરિયા વકીલ શ્રી કે ગરિયા વકીલ શ્રી અંતિ દેસાઈ વકીલ શ્રી અંતિ દેસાઈ વકીલ શ્રી આનંદ દેસાઈ વકીલ શ્રી આનંદ દેસાઈ વકીલ શ્રી એસ કાપડિયા વકીલ શ્રી એસ કાપડિયા વકીલ શ્રી જેબી પટેલ વકીલ શ્રી જેબી પટેલ वकील श्री एसी गरासिया वकील श्री पीएन पटेल वकील श्री पीएन पटेल वकील श्री बीबी नायक वकील श्री आरजे देसाई वकील श्री बीबी नायक वकील श्री अमित पटेल वकील श्री प्रथम 58-24 में साइड मारी रेगुलर सिविल अपील છે हाँ साहब जी सर आज प्रथम डेट 16 हाँ आई मोबिलाइज
सर सिविल में सीरियल नंबर 12
અરજદાર નંબર 2 તરફે અસલ પાવર ઓફ એટર્ની આજે રજૂ કરીએ છીએ લાસ્ટ ટાઈમ ઝેરોક્સ રજૂ કરેલો હતો અને ક્લોઝિંગ પ્રોસેસ પણ આપી દીધું છે
સર બંને તરફે ક્લોઝિંગ પ્રોસેસ આપી દીધું છે taken as heard taken as heard
अच्छा
વોરંટ કાઢવા કેવાનું शेर नंबर 4 क्रिमिनल अपील
77 એક્ઝિક્યુશન માટે છે. બસ એક નંબર રિસ્પોન્ડન્ટને બચવા પર છે. અક્વિટલ અપીલ છે. વિક્ટીમે કરી છે. માં લો પોઈન્ટ છે એટલા પૂરતું 299 નો ભંગ છે. નંબર 6 પર છે પેલો દંડ ભરવાનો છે સાહેબ 20%. ચેક ચેક અમાઉન્ટ ના 20% ભરવાના છે કે દંડના 20% ભરવાના? સાહેબ આજે હું અડધા ભરી દઉં છું, અડધા સાહેબ એક મુદત આપું, અડધા આવતી મુદતે સાહેબ ભરી દઉં. 20% સાહેબ દંડની રકમમાં ભરવાના છે સાહેબ, અને 77 એમના સાહેબ ડબલ છે સાહેબ દંડ. એક ચોપન 130 રૂપિયા છે સાહેબ. ચેક અમુકના ડબલ રકમ દંડ. તો સાહેબ હું આજે જ ભરી દઉં છું. જી સાહેબ, જી સાહેબ.
સિવિલમાં તો સી નંબર 4 BMADC 13/25 ભરવા માટે હાજી સેપરેટ ડીલે ગ્રાન્ટ કરી છે ફક્ત બની એ ગ્રાન્ટ કરી આપશે બે એટલે રેસ્ટોરેશન પર આવે હાજી ऐसे सीजन पर 9 पर છે રેગ્યુલર સિવિલ અપીલ मैं એપેલેન્ટમાં જેજી મહેતા સાથે સાહેબ હું છું હા હા પબ્લિક પબ્લિક
બરકે કે ચપ્પર જવા છે
તેર નંબરમાં સાહેબ આ ચોથી મુદત છે અમે નવસારીથી આવીએ 13 નંબર ને ક્રિમિનલ સેશન્સ કેસ સિવિલ હોય તો ક્યાં આપણે ચિંતા હોય સાહેબ આ તો કે અમારે ક્રિમિનલ આવવું પડે નવસારીથી આવીએ અમે અને મહિલા છે
Hello, hello. 1, 2, 3 testing. Mic number 1.
25-21 એટલા માટે
Hello, 1, 2, 3. Mic number 2.
ચારેક વખતથી નથી આવતા હા ઉતાવળ એટલા માટે અમે સાહેબ તો આવીએ નહીં હું
Hello,
મહિલા છું ને સાહેબ.
mic number 4. Mic number 4. Mic number 3. Hello, hello, hello.
આવું એવું માનું છું કે એનો બંધ કરવો જોઈએ હવે આટલો લાંબો ટાઈમ થયો એટલે હાજી હાજી તો સાહેબ એનો તો એવો અમે જ હવે તો મહિલાથી અમે શું કરીએ અમારું કોઈ જગ્યાએ નામ નથી છતાંય અમારે ધક્કો આવવા પડે છે અમે પણ તો મહિલા છે એને તો આવવાનું ને સાહેબ પરમેનન્ટ ને આપી દો નહીં, હવે તો હું ભાઈઓ પાસે તો ઓળખની દરકાર કઈ એની પાસે તો કઈ હોય જ નહીં આવ્યો છે? એ બોલો દક્ષાબેન બિચારી શું છે મજૂરી કરીને તો પણ તો મારે આવવું પડે છે એ તો મારે નવસારીથી આવવું બહુ સેમ થયું છે ઠીક છે. जी साहेब आवेला आहे. मंथन उगा ₹4.5 ચાર ચાર point. એટલે સાહેબ 20% રકમ એમને મળેલી છે. 23 લાખની 20% રકમ એમને મળેલી છે. જી જી 4,60,000 ની આજુબાજુ 4,60,000. સાહેબ બીજું સાહેબ થોડુંક એરેન્જમેન્ટ કરીએ સાહેબ. અમારે એક પેમેન્ટ મોટું બાકી છે સાહેબ. હા જી સાહેબ હું આપી દઉં અત્યારે જ આપી દઉં સાહેબ પ્લીઝ પ્લીઝ વિલ ડુ હું અરજી આપું પ્લીઝ થેન્ક યુ સર થેન્ક યુ બરાબર સર.
જી સર. જી સર ભરાઈ ગયા છે. ના.
એની ક્લોઝિંગ અમારા બેની એનો પુરાવાનો હક બંધ કરવા માટે વિકલ્પે એને દંડ કરો. ઓક્ટોબર 2024 થી સાહેબ નથી એવું મારા મિત્રને પૂછ્યું ત્યારે ખબર પડી. જરાક વધારે પડતી લંબાઈ. હા સાહેબ 300 બહેનો છે એને કઈ વિષય એવી તો સત્તા નથી મળી તેને નહીં આવવાનું અને પીપીને એમ કહી દેવાનું કે હું આવું છું અને મારે પુરાવો આપવો જ નથી. એવું તો ના જ હોય ને સર. હજુ તો આવ્યા જ નથી કે આવ્યા આવી ગયા અને આવીને જાય ને પુરાવો ન આપે તે તો યોગ્ય નથી ને. હાજી સર. સાહેબ એવા પૈસા ક્યાં છે અમારી પાસે? અમે તો આપની પાસે ન્યાય ઝંખીએ છીએ. વેટ ન્યાય માટે કાયદા માટે તો એવું તો નથી કે સાહેબ 302 હોય કે 323 હોય સાહેબ. હું એવું હા એટલે આ તો તમે સાની અરજી આપો. બીજી કોઈ જોગવાઈ નથી મને નથી લાગતી કોઈ જોગવાઈ હોય એવી.
I'm sorry, I'm late by 5 minutes.
No, it's no problem, Dolbe.
No, I was just trying to log in. And I can start now, sir, with your honor's permission.
Dolbe, now we can start, no problem.
I can start now.
Yes.
Sir, I appear for the original plaintiff, respondent number 1 in the present appeal
Yes.
from order, that is Jindal Flexi Films Limited.
Yes.
Now, sir, the hearing is in respect of application filed in the present appeal from order seeking stay of the implementation and operation of the impugned judgment and order.
Yes.
Hope I am audible to your honor perfectly.
Yes, 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 very clearly.
So my first submission is that at present, what is to be or what is agreed to be taken up for hearing on 1st March 2025, when we appeared before your honor physically, and hearing could not take place on account of ill health of Mr. Soparkar. At that point of time, it was agreed that matter would be heard for the purpose of application seeking stay of the impugned judgment and order moved by the present appellant. Now, if we look at that stay application, if your honor is having on hand the stay application which the present appellant has filed in present appeal from order, most probably it will be exhibit 4 or 5. There is an application titled application for ad interim stay under section 151 of the Code of Civil Procedure 1908. Am I with your honor on that? We are on the same page.
Yes, yes.
Now let us have a look at the prayer of this application. Prayer, your honor would find in paragraph 30, page number 24. Pages are at the bottom. The applicant therefore prays as under.
Yes.
Prayer. Pending the hearing and disposal of the present appeal, the operation of the impugned order dated 20th February 2025 in commercial suit number 5 of 2025 be stayed by this honorable court. So they have asked for the stay of the implementation and operation of the order passed by the trial court below Exhibit 5 in the commercial civil suit. And Exhibit 5 was an application under Order 39, Rule 1 and 2. So my first submission is,
Yes.
what is sought to be stayed is the impugned order of the trial court. Therefore, let us have a look at the impugned order of the trial court. What was granted, what is now sought to be stayed. Page 17, there is a paper book given by them. And in paper book, in the present appeal, at page 17, there the pages are at the top. The judgment and order delivered by the trial court, which is impugned in the present appeal, and of which the stay is prayed for by this interim application, figures at page 17. The operative part of this order, Your Honor would find on page 38.
Yes.
Now, I'd like to read page 38, operative part of the order, because while this application for stay in the present appeal, they have prayed for stay of this operative part of the order. Interim injunction application of the plaintiff under Order 39, Rule 1 and 2 of CPC, while Exhibit 5 is hereby granted. In the meantime, defendants and shareholders of defendants be directed to maintain status quo in respect of the disputed transaction regarding suit property, and they are restrained from transferring the shareholding of defendant number 1 and 2 directly or indirectly or through their subsidiaries or officials in any manner till disposal of this suit. And then defendants and servants, the capacity of principal or agent acting for on behalf of anyone naming through by or under them are restrained from transferring, alienating, or creating any third-party interest in the shareholding of defendants or dealing with such shareholding in any manner. So, meaning by which trial court has virtually ordered status quo to be maintained in respect of the transaction forming subject matter of the present civil suit before the trial court. Basically, it's a prohibitory order. Interim injunction pending commercial suit, as it evident from the reading of the impugned order, is prohibitory in nature. Now, if this order is to be stayed, in my respectful submission, what is the virtual effect? The virtual effect is allowing the appeal at this stage. Because if an interim order of a prohibitory nature, whereby the defendants are directed to maintain status quo with regard to the transaction in question and not to undertake any further activity in respect of the same. If that prohibitory order is to be stayed pending final disposal of appeal from order, in my respectful submission, the virtual effect is to allow the appeal. And I'll demonstrate that and make good. Because once this order is stayed, meaning by which the defendants are at liberty to proceed further with the transaction in question, for which they are restrained from undertaking further steps by maintaining a status quo. Now, if they are permitted to go ahead with the transaction in question, which is stayed by this order, sir, even if I succeed in the appeal thereafter, and the appeal is not allowed, and finally on final hearing of the appeal, the honorable court is not inclined to allow the appeal, sir, in my respectful submission, it will be next to impossible to put the clock back. Because once this order is stayed, they would be free bird. They would be undertaking going ahead with the transaction, which is now halted, stayed, stopped by the order of this honorable court. So the first question in my respectful submission, which emerges for kind consideration by your honor, can be framed this by that: will it be permissible on the part of the present appellant to seek stay of an interim order of a prohibitory nature pending final disposal of the main appeal from order. And the answer to this question, in my respectful submission, is in negative. No order of stay of the impugned judgment can be granted at this stage when finally the appeal is to be heard. At the most, they would be entitled to seek an early, expeditious disposal of the appeal from order which is pending before your honor, to which, subject to the workload of your honorable court, I cannot have any jurisdiction in agreeing for any date which the honorable court may deem fit and proper to decide the main appeal. Now, when I say that there is no scope for stay in such situation when the order is prohibitory in nature, sir, I am supported by the judgments of Honorable Delhi High Court and the Honorable Calcutta High Court in identical fact situation. So first, I would like to place reliance on the judgment of the Honorable Delhi High Court reported in 2022 SCC Supreme Court cases, online, Delhi, page number 2856, in the matter of Muhammad Sakil versus Muhammad Islam. May I request, Kavya, is there, can you just screen share or someone can give to the honorable? ना साहब उस अवसर कोई हमारा लोकल ना हो तो एडवोकेट देन आई विल डू वन थिंग હું સ્ક્રીન શેર કરવાનો ફિઝિકલ
નથી આવે છે
નથી આપણે લોકલ એડવોકેટ ત્યાં
આવે છે મિસ્ટર કક્કડ કરીને હોય છે ધવલભાઈ પણ
હા હોય છે કક્કડ આવ્યા ના તો અમે એમને જજમેન્ટ બી કયા છે કે તમે ફિઝિકલી તૈયાર રાખજો જે રીતે આપી શકે I don't think he is there. Anyhow, some will
I think he is late today. આવવાના છે કે વાત થઈ?
સાહેબ, મને એવું કહ્યું કે મારા કોઈ કલીગ ને મોકલાવું છું, એવી મારી 20 મિનિટ પહેલા વાત થઈ હતી.
અચ્છા કઈ વાંધો
there I am trying to work it out.
વાંધો નહીં ધવલભાઈ, you just mention the judgments, I will note down, and we are also having an online platform.
Okay, that's fine. Now I am also trying to ask my Delhi office of my instructing advocate to screen share on the your within a 5 minutes. We are just arranging that so that will be easier.
If I could just get permission to screen share, I don't have the permission.
Sir, if your honor will have to instruct the office to.
થઈ શકશે ને? જસ્ટ મિનિટ, આપણે રવિભાઈને બોલાવો.
એમાં સેટિંગ્સમાં
સેટિંગ્સમાં એ કરવું પડશે ને?
પરમિશન આપવી પડશે.
હા, પરમિશન આપવી પડશે.
હા ધવલભાઈ, હું કરાવું છું હમણાં એ લોકો.
હા, no issue, sir. No issue.
There is a first point is that
Sir, મારો first submission is therefore એ છે કે જ્યારે prohibitory injunction હોય, એ prohibitory injunction થી માત્ર parties have been restrained from doing further act, status quo જાળવવાનું કહ્યું હોય, એવી અપીલની અંદર સ્ટે આપવામાં આવે તો એનો મતલબ એવો થયો કે અપીલ આખી એલાઉ સાહેબ થઈ ગઈ, કારણ કે પછી એ સ્ટે ઉઠી જાય અને ટ્રાન્ઝેક્શન કરી નાખે તો મારે સાહેબ એને ક્લોક પાછું કેવી રીતે લાવવું? એટલે આવો પ્રશ્ન દિલ્હી હાઈકોર્ટ સમક્ષ આવ્યો કે wherever there is a prohibitory order of injunction, say let us give an example, સાહેબ હું સરસ કોન્ક્રીટ એક્ઝામ્પલ આપું કે if there is a suit asking for a declaration that defendants have no right to demolish my construction, and pending that suit is some injunction application api કે defendants be restrained from demolishing my construction. કોર્ટે ટ્રાયલ કોર્ટે ઓર્ડર આપ્યો કે કન્સ્ટ્રક્શન ડેમોલિશ નહીં કરો, એની સામેની અપીલ આવી સાહેબ. હવે અપીલમાં જો સ્ટે કરી દેવામાં આવે ઓર્ડર તો બીજે દિવસે ડેફોરેન્સ કેન ડેમોલિશ થઈ તો અપીલમાં ચલાવવાનું શું રહે? એવી જ રીતે અહીંયા આગળ સાહેબ ટ્રાન્ઝેક્શન ઇન ક્વેશ્ચન શેર ટ્રાન્સફર જે કરવાનું છે અમે એમ કહીએ છીએ કે ઇટ વોઝ એગ્રીડ કે ડિફરન્ટ નંબર 1 નું શેર હોલ્ડિંગ વાદીની તરફેણમાં આપવાનું ડાયવેસ્ટ કરવાનું એના અંગેનો સાહેબ કોન્ટ્રાક્ટ કન્ક્લુડેડ થયો હતો અમે બંને પક્ષકારો એના પર વેરિયન્સ ઉપર જે કન્ક્લુડેડ કોન્ટ્રાક્ટ કહેવાય કે નહીં so that's an issue main issue to be decided in the main appeal today when we are considering the stay application so at stay application ની અંદર જો આ ઓર્ડર સ્ટે કરી દેવામાં આવે પ્રોહિબિટરી then સાહેબ રહ્યું શું તો પછી તો then in that scenario tomorrow they will execute their transaction with another party and my entire suit will become infectious sir forget about the appeal form order. Therefore, in my respectful submission, pending appeal from order, there cannot be stay of such an order. And this is what exactly the Honorable Delhi High Court had an occasion to deal with in the case which I am referring to. I think now screen sharing permission it must be. Kavya, have you got the screen sharing? Then please share on screen judgment on the matter of Muhammad Shakil, 2022. Yes, sir. Paragraph number 10 may be seen, sir. Hope it is legible for your honor from the screen to read, or we can increase the font. She can increase the font. Yes, paragraph 10. Where a judgment or a decree is injunctive in nature, that is where the judgment or a decree injuncts either of the parties before the court from performing any particular act, ordinarily, no stay of such an order can be sought as it would amount to placing the clock back and restoring the status quo ante. More roughly expressed, a stay order cannot be stayed save in a rare and exceptional cases where restoration of the status quo ante at an interlocutory stage is imperative in the interest of justice. The judgment and decree dated 11th January 2022 of the learned additional district judge merely injuncted the petitioners from dispossessing the respondent from the suit property. Such an order, though amenable to challenge, cannot be stayed. There cannot be stay of a direction not to dispossess. Had the order been in a positive order directing placement of anyone in possession, such an order could have been stayed, as it would be an order directing a positive act to be performed. An order which restrains dispossession cannot ordinarily be stayed at an interlocutory stage. It would also result in grant at an interlocutory stage of the final relief sought in the appeal, which is also impermissible. So the Honorable Delhi High Court in this judgment has categorically drawn a line of distinction between a preventive or a prohibitory order and an order directing some positive act. And the Honorable Court says that so far as prohibitory preventive orders are concerned, they cannot be stayed pending final disposal of the appeal because it would tantamount to allowing the appeal at an interim stage, which is not permissible. And the court has also given an example of the facts before it, that if someone is restrained from dispossessing, and if I stay the order, then the man will be dispossessed. The same example which I gave of a construction, that if construction is to be not demolished, that's an injunction order. And if that order is to be stayed pending final disposal of the appeal, then in my respectful submission, it would tantamount to allowing the appeal. So this is the view taken by Honorable Allahabad Delhi High Court, supporting what exactly I was submitted before your honor. The second judgment is in the matter of Hindustan Liver versus Imami Limited 2018 SCC Online, Calcutta 8882. So there, once again, an identical situation arose. To save the time of the Honorable Court, I would like to straight go to paragraph 36. So we'll see that all judgments are physically there before your honor by the end of the day.
Yes.
On a different aspect, it is well settled that stay of operation of a prohibitory injunction is generally refused on the ground that a grant of a stay would amount to allowing the appeal itself at a premature stage, thereby negating the effect of the impugn order itself. Such stay can be granted only in exceptional circumstances and in rare cases. So meaning by which there has to be an exceptional case where the impugn order cannot be permitted to be stayed even for a moment. Say for example, that a suit for construction, demolition of a construction, restraining the defendant from demolishing the construction. And the construction is coming in the way of some important project of a public importance. Say, for example, that the construction is coming in the way of widening of a road which is of very emergent public nature. And in that case, if it is made out that the plaintiff is not having a semblance of case and the construction is really illegal and unauthorized in nature without any permission, in such a scenario, in exceptional cases, the court can stay a prohibitory order. But not in a normal cases. This is a normal case where a court of a competent jurisdiction, a commercial court, on appreciation of evidence on the record, comes to one conclusion that this is a case where my intervention is required, interim relief is required, transaction is required to be stayed from going ahead. In that scenario, in my respectful submission, it's not an exceptional case where order is required to be stayed pending final disposal of the appeal before your honor. And what is the rationale behind this proposition? Rationale is that if you stay such an order, you are granting final relief at an interim stage. And that cannot be done because there has to be a distinction between a final relief and the interim relief. Interim relief is always in the aid of the final relief. It cannot be for the purpose of rendering the final relief nugatory, non-est. And this is what even the Honorable Supreme Court had an occasion to deal with this very issue. And that is, we have referred to in our reply. If your honor is kind enough, we have filed our reply to application for stay. And wherein we have filed an exhaustive reply dealing with the stay application of which the hearing is going on at present before your honor.
Yes.
Sir, in paragraph 30, after paragraph 29, we have pointed out granting, heading is granting of an interim relief would tantamount to granting the final relief itself. And therein, having quoted the two reliefs which I read before your honor, that they are seeking virtually stay of the order, which is of a prohibitory nature. So we have referred to various judgments, out of which I would like to first rely upon judgment reported in 2005, volume 9, SCC 733, State of UP versus Ram Shuki Devi. Can you please screen share that?
I think Gaurav, you have also mentioned operative part in your written arguments.
Yes, we have mentioned that operative part here, which I read before your honor from the original application.
Yes.
Now, since your honor is on the operative part, again I go back to the operative part. Operative part, first of all, they stay this order, and the operative part which I read before your honor simply prohibits them from going ahead with the transaction, requires them to maintain status. Now, in that scenario, in this judgment, in paragraph 8, this is what the Honorable Supreme Court had to observe, where an interim relief of a final nature was sought in a petition. Paragraph 8. To say the least, approach of the learned single judge and division bench is judicially unsustainable and indefensible. The final relief sought for in the petition has been granted at an interim measure. There was no reason indicated by the learned judge as to why the government order dated 26 October 1998 was to be ignored. Whether the writ petitioner was entitled to any relief in the writ petition has to be adjudicated at the time of final disposal of the writ petition. The court has on numerous occasions, and I would like to emphasize this, the court has on numerous occasions observed that the final relief sought for should not be granted at an interim stage. The position is worsened if the interim direction has been passed with the stipulation that the applicable government order has to be ignored. Time and again, this court has deprecated the practice of granting interim orders which give principal relief sought in the petition for better reason than that of a prima facie case having been made out, without being concerned about the balance of convenience, public interest, and a host of other considerations. The Honorable Supreme Court said we deprecate the practice. Now, sir, in light of this observation, Your Honor may again turn to my reply, paragraph 30, where I have given a comparison of final relief and the interim relief prayed for in the present stay application in present appeal from order. So, paragraph 30. It is submitted that, am I with Your Honor?
Yes, yes.
It is submitted that allowing the present application and granting the interim relief would tantamount to granting the final relief in the present case. The relief sought for in the present application, there is stay application before Your Honor, of which the hearing is presently pending hearing and final is on a present appeal. The operation of the impugn order dated so and so in commercial and be stayed by this honorable court. And the final relief in the appeal in the next paragraph I have quoted. Further, the final relief sought in the accompanying appeal filed by the appellant report is below. Allow the present appeal and set aside the final order pending hearing of the present and stay the application. So final relief and the interim relief, there is no distinction, can't be. Whenever there is a prohibitory order of injunction, so in my respectful submission, there is no scope for stay of that order. Because nothing remains thereafter in appeal to be heard. And then judgment of the Honorable Supreme Court, two judgments of the Honorable High Court, and the last judgment on the score is of our Honorable High Court in the matter of Rasila Ben 1998, SCC Online, Gujarat 396.
Yes.
Paragraph, it will be shown on the screen. Paragraph 8. From the decision of the Apex Court, which I briefly referred above, legal position is clearly laid down that in the case of a grant of interim relief pending final disposal of the final matter, the court should have been very careful and should take note of the fact that interim relief may not result in grant of final relief, which has to be granted only after full-fledged trial of the suit when the court is satisfied that a plaintiff has proved the case. Grant of temporary injunction, more so in the matter of appointment of, that's one of the facts of the case. The proposition is that even in a suit you cannot grant an interim relief of a present matter, final nature. Sir, therefore, something cannot be done in a suit cannot be done also in an appeal from order. So in my respectful submission, summing up my first submission, so this is my first submission, that the relief paid for in the present stay application of the appellant for which the hearing is scheduled today cannot be granted for the reason that if such relief is granted, it would tantamount to allowing the appeal at an interim stage by granting the final relief, interim relief of a final nature, which is not permissible in law in view of judgments directly on the point of Honorable Delhi High Court, Honorable Calcutta High Court, and observations of the Honorable Supreme Court in two judgments. One judgment of Supreme Court by the Honorable Gujarat High Court. Then no relief of a final nature can be granted at an interim stage. Therefore, on this very count itself, without investing much time of the Honorable Court, the appeal from order is required to be set down for final hearing, subject to the convenience of the Honorable Court. Now, without prejudice to my this first submission, since the other side has argued at length the stay application and assailing the judgment of the trial court on merits, I would like to proceed further without prejudice to my first contention that it is possible for the appellants to seek stay of the impugned judgment and order. So my second submission is that even if the present appellant, original defendant number 1, is entitled in law to pray for stay of the impugned judgment and order, which is of a prohibitory or a preventive nature, directing parties to maintain status quo. Then also, considering the narrow compass of your honor jurisdiction in respect of the present appeal from order, the stay application is not required to be entertained. Because in my respectful submission, the stay application of the present appellant cannot travel beyond your honor's jurisdiction under Order 43 of the Code of Civil Procedure, pursuant to which the present appeal from order is filed by the appellant. So it's not in dispute that the present appeal is under Order 43, Rule 1, Subclause R of the Code of Civil Procedure, read with the relevant provisions of the Commercial Courts Act, namely Section 13. That is only for the purpose of conferring a jurisdiction upon your honor. Otherwise, the source of appeal is Order 43, Rule 1, Subclause R. Now, dealing with the scope of appeal, sir, in our reply to the present stay application, sir, paragraph 1.5, limited scope of appeal from order. We have titled paragraph 1.5.
Yes.
Am I with your honor? Paragraph 1.5.
Yes.
Limited scope of appeal from order under Order 43 CPC. It is submitted that the scope of appeal under Order 43 of CPC is limited and narrow. The court can interfere with the discretion of the lower court only when the discretion is exercised in an arbitrary or a perverse manner. If the trial court exercises discretion reasonably and in a judicial manner, the appellate cause inclination towards different view would not by itself justify interfering with that discretion. Now, I'll elaborate. Then we refer to judgment also. Sir, way back in 1990, in Wonder Limited, the Honorable Supreme Court had an occasion to consider the scope of appeal from order under Order 43. The Honorable Supreme Court says that there is a distinction between a regular appeal under Order 41 of the Code of Civil Procedure against the final decree and an appeal under Order 43 against an interlocutory order. So far as the former, that is appeal under Order 41 against the regular and the final decree is concerned, the scope is very wide because the appellate court under Order 41, read with Section 96 of the CPC, is empowered to reappreciate the evidence and come to a finding other than the one recorded by the trial court on appreciation of the evidence. To be very precise, in a regular appeal arising out of the final decree, your honor sitting as an appellate court would be entitled to upset the finding recorded by the trial court on appreciation of the evidence by holding that I am of a different view and I would not like to subscribe to the view taken by the trial court. But same jurisdiction is not available to your honor when your honor is taking up an appeal from order under Order 43, Rule 1, Subclause R of the Code of Civil Procedure against an interlocutory order. And the Honorable Supreme Court has gone to the extent of saying that even if in the considered opinion of the appellate court under Order 43 of CPC, a second view is possible and the Honorable Court would like to take their second view, it is not permissible to replace the view taken by the trial court with their second view to which the appellate court would like to subscribe. And therefore, the Honorable Supreme Court, in the case of Wonder Limited, reported in 1990 supplementary Supreme Court cases 727, sir, paragraph 40 is worth referring to, wherein after leaving about the first line, in such appeals, now I'll read from the paragraph 14. The appeals before the division bench were against the exercise of discretion by the single judge. In such appeals, the appellate court will not interfere with the exercise of discretion of the court of first instance and substitute its own discretion except where the discretion has been shown to have been exercised arbitrarily or capriciously or perversely, or where the court had ignored settled principles of law regulating grant or refusal of interlocutory intentions. In an appeal against exercise of discretion is said to be an appeal on principle. The appellate court will not reassess the material and seek to reach a conclusion different from the one reached by the court below if the one reached by the court, that court, was reasonably possible on the material. The appellate court would normally not be justified in interfering with the exercise of discretion under appeal solely on the ground that if it had considered the matter at the trial stage, it would have come to a contrary conclusion. If the discretion has been exercised by the trial court reasonably and in a judicial manner, the fact that the appellate court would have taken a different view may not justify interference with trial court's exercise of discretion. So clear distinction drawn between a regular appeal against a decree where your honor jurisdiction is very wide, your honor can reappreciate the evidence and come to a conclusion other than the one recorded by the trial. But in an appeal from order under Order 43, which has been construed as an appeal on principle, where the Honorable Supreme Court says the appellate court cannot reappreciate the evidence and come to a conclusion different from that of the trial court, the only discretion, only exception is if it is pointed out that trial court's decision is arbitrary, that is without application of mind, capriciously or perversely, and without following the settled principles of law, meaning by which all must be given proper opportunity of hearing and all this. Hearing the facts of the case, in my respectful submission, the trial court gives ample opportunity to both the parties, deals with evidence on the record, comes to a conclusion that there is a concluded contract. In my respectful submission, before the trial court, the principal issue was whether, because at the stage of the grant of interim relief, whether there was a concluded contract between the parties. Number one, if yes, whether defendants have committed a breach of their contract. And number three, if defendants have committed a breach, whether they are required to be restrained from committing further breach or not. These were the issues. Now, the trial court takes into consideration each and every document on the record and comes to a conclusion on appreciation of that documentary evidence that here I would like to read a concluded contract by the conduct of the parties. Sir, putting a question to myself, is it not within the jurisdiction of the trial court to take one view or other of the matter? It could have taken a view there is no concluded contract. It could have taken a view there is a concluded contract. If the trial court, in its discretion, upon considering and appreciating the documentary evidence on the record, comes to a prima facie conclusion that there is a concluded contract, sir, how that decision of the trial court can be said to be either arbitrary, capricious, or perverse in nature, so as to seek interference of your honor in the present appeal from order under Order 43. Because Supreme Court is very clear, sir, Honorable Supreme Court, that unless it is capricious, arbitrary, and perverse, that discretion cannot be interfered with. The Honorable Supreme Court has gone to the extent of saying that even if your honor, sitting as a trial court, were to take a different view, then also your honor cannot replace the view taken by the trial. Now, if this is the position in my respectful submission, assuming without admitting, without prejudice my first submission, that they are entitled to place into service the present said application on merits. Sir, how the contention that trial court has wrongly come to a conclusion that there was a concluded contract can be accepted? Sir, ultimately, the argument of Mr. Soparkar in pith and substance was predominantly, mainly on the ground that trial court concluded contract જે માન્યો છે એમાં એમણે ભૂલ કરેલી છે. આ documentary evidence ઉપરથી concluded contract છે એવું ફલિત ન થાય. That was the precise argument, Mr. Soparkar, in one line. To which my answer is, you are requesting your honor, Mr. Soparkar thereupon is requesting your honor to reappreciate the evidence in present appeal from order and requesting your honor to take a different view from the one taken by the trial court, which the Honorable Supreme Court way back in 1990 said is wholly impermissible in law. Honorable Supreme Court has gone to the extent of saying that even if the appellate court under Order 43 is to come to a conclusion that finding recorded by the trial court on appreciation of the evidence is wrong and erroneous, then also it cannot be replaced in appeal from order. This is a very narrow compass of this appeal. And despite that, in my respectful submission, the appellant is pressing his stay application, seeking stay of the impugned judgment and order. Now, this judgment of the Honorable Supreme Court, which commenced with Vendor Limited way back in 1990, sir, further came to be reiterated by the Honorable Supreme Court in the case of Mohammad Mehtab Khan, reported in 2013, 9 SCC 221. And all these judgments, sir, we have categorically referred to in our reply.
Yes.
Now, sir, I would like to request Kavya to screen share that judgment. 2013, 9 SCC 221. Paragraph 20 is the relevant paragraph. Sir, all these were the cases under Order 43, Rule 1, Subclause R. Vendor remitter was also under 43. This is also under 43. Order 43.
Right.
In a situation where the learned trial court, on consideration of the respective cases of the parties and documents laid before it, was of the view that the entitlement of the plaintiff to an order of interim mandatory injunction was in serious doubt, the appellate court could not have interfered with the exercise of discretion by the learned trial judge unless such exercise was found to be palpably incorrect and untenable. The reason that weighed with the LNA trial judge, as already noticed, according to us, do not indicate that the view taken is not a possible view. Sir, I would like to take a pause with your Honor's permission. The Honorable Supreme Court says, if the view taken by the trial court is also a possible view, then that view cannot be upset in appeal form order. Sir, turning here to the facts of the case, trial court is entitled to have a view on documentary evidence on the record to the effect that I read into this evidence a conclusion. There's a possible view. It may not be a correct, it may not be a correct. That is to be decided as and when the suit is finally heard. Today, the trial court is conferred with the jurisdiction to take a one view or other on the basis of the appreciation of the material and the evidence. That view cannot be corrected. That's what the Supreme Court says. Then further, the appellate court therefore should not have substituted its view in the matter merely on the ground that in its opinion, the facts of the case call for a different conclusion. Such an exercise is not correct parameter for exercise of jurisdiction while hearing an appeal against discretionary order. While we must not be understood to have said that appellate court was wrong in its conclusion, what is sought to be emphasized is that as long as the view of the trial court was possible view, the appellate court should not have interfered with the same following virtually settled principle of law in this regard as laid down by this court in the Vendor Limited and versus Entox India. So thereafter in paragraph 21, now sir, here the contention of Mr. Soparkar is to be accepted for appellant for the purpose of stay application. The appellant is requesting your honor at an interim stage of an appeal from order to do something which your honor would not be in a position to at the final hearing of the appeal from order. Sir, these are the things which are concerned with the scope of the main appeal. If the main appeal does not permit your honor to replace the discretionary view taken by the trial court on appreciation of the evidence on the record, sir, where is a question of considering the same at the interim stage of an appeal from order where they are seeking stay of the order. The next judgment on this point is in the matter of Neon Laboratories, 2016, Volume 2, SCC 672, paragraph 5. This is also an appeal from order under Order 43. Sir, paragraph 5, after leaving about 5 to 6 lines, the sentence, however, yes, the cursor is there. However, it is now well entrenched in our jurisprudence that the appellate court should not flimsily, whimsically, or lightly interfere in the exercise of discretion by a subordinate court unless such exercise is palpably perverse. Perversity can pertain to the understanding of law or the apprehension of pleadings or evidence, we shall restrict ourselves to the reference in vendor limited versus Entox India Private Limited, wherein it has been enumerated that the appellate court ought not to reassess the material and seek to reach a conclusion different from the one reached by the court below, if the one reached by that court was reasonably possible on the material. The rest I read beginning from vendor's case, so I am not reading it again.
Yes, yes.
Now, so this is the view taken by the Honorable Supreme Court, again confirming vendor's principle in 2016. Now, sir, recently, very recently, in 2024, the Honorable Supreme Court thought it fit to revisit the issue arising from the judgment of the Honorable Gujarat High Court. And my Lord Justice Padiwala, speaking from the Honorable Supreme Court in this matter of Ramakant Ambalal Choksi, 2024 SSC Online SC 3538, explain in detail, expanding and explaining in detail the ratio laid down in vendor's case. Because here, the trial court granted an order of injunction in a suit for specific performance, restraining the defendant from transferring the land further. So prohibitory order was passed like our case. That order of injunction was interfered with by the High Court in an appeal from order. Resultantly, the defendant entered into a further transaction. And when the matter landed before the Honorable Supreme Court, sir, in paragraph 20 of the judgment, the Honorable Supreme Court thought it fit to address the issue with the heading Appellate Jurisdiction under Order 43 of the CPC. Because your Honor's jurisdiction is under Order 1. Order 43 of the CPC specifies the orders against which an appeal lies. Subrule 2 of Rule 1 of the said order provides that an appeal would lie against an order made under Order Rules 1, 2, 2A, 4 and 10 of Order 39 of CPC respectively. The law in relation to the scope of an appeal against grant or non-grant of interim injunction was laid down by this court in Vendor Limited versus so and so. Entox brought an action of passing off against vendor with respect to the mark called say the trial court declined Entox plea for an interim injunction. However, appeal, the High Court reversed the reversed the findings of the trial judge. This court, upon due consideration of the matter, took notice of two egregious errors said to have been committed by the High Court. First, as regards scope and nature of the appeals before it and the limitation of the powers of the appellate court to substitute its own discretion in an appeal preferred against a discretionary order. And secondly, the weakness of deterioration as to the quality of Entox alleged user of the trademark on which the passing of action is founded. That clause B would not be relevant for our purpose. We are concerned with one only. With regard to clause A, this court held thus, sir, I can skip reading of that.
Yes.
It is quotation from vendor's judgment again. So I am just skipping it with your honor's permission. And then paragraph 27 would be relevant.
The principles of law explained by.
Yeah, the principle of law exercised, explained by this court in vendor's case have been reiterated in number of subsequent decisions of this court. However, now this is very material. However, over a period of time, the test laid down by this court as regards the scope of interference has been made more stringent. Sir, I am posing for a moment. In 2024, the Honorable Supreme Court, while dealing with a situation where the order of the trial court in the suit granting injunction of a prohibitory nature was interfered with the Honorable High Court and matter landed before the Honorable Supreme Court. Referring to the vendor's case, the Honorable Supreme Court says that what was laid down in 1990 in vendor's case has been made more stringent over a passage of time. The emphasis is now more on perversity rather than mere error of fact or law in granting injunction pending the final adjudication of the suit. Sir, the scope has been made further narrower by clarifying that except perversity, the appellate court under order 43 should not consider as to whether the finding is right or wrong, either on facts or in law. Sir, the compass of your Honor's jurisdiction under order 43 has been made so narrow following the principle of vendor's case in this judgment by stating that 7 except perversity, nothing else is required to be looked into. Appellant before your honor, therefore, cannot contain that look, this finding recorded by the trial court on the aspect of concluded contract is contrary to the facts, is contrary to the law. The Honorable Supreme Court says no. Even if there is error of law or fact in recording a finding that cannot be interfered with, it can be interfered with only if it is found to be perverse in nature. Thereafter, sir, in paragraph 28, Neon Laboratory, which I referred to, has been referred. Then in paragraph 29, Muhammad's case, which I referred to, has been referred. And then, sir, in paragraph number 37, the Honorable Supreme Court thought it fit to explain what is meant by perversity. Because vendor's case, Neon Laboratory, Muhammad case, and in 2024, this Ramakant case, all cases say that unless and until the judgment of the trial court is found to be perverse in nature, the finding recorded by the trial court cannot be interfered with. Error of law, error of fact cannot be corrected. But having said so, in 2024 judgment, the Honorable Supreme Court thought it fit to explain the meaning of perversity. And it is explained this wise. The word finding should stem out on a complete misreading of evidence or should be based only on conjectures and surmises. The far-fetched approach on perversity is the classic approach on the reasonable man's interference on facts. To him, if the conclusion on facts in evidence made by the court below is possible, there is no perversity. If not, the finding is perverse. Inadequacy of evidence or a different reading of evidence is not perversity. This is very material. Inadequacy of evidence or a different reading of an evidence is no perversity. Because ultimately the appellate before your honor is contending that the trial court has wrongly appreciated the correspondence on the record, being the documentary evidence, to come to a conclusion that there is a concluded contract. That's, in my respectful submission, fall in the expression used by the Honorable Supreme Court, different reading of the evidence is no perversity. Even if appellant is right in his contention, I go to the extent of saying that reading of the documentary evidence on the record by the trial court is erroneous. That is not permissible to be raised in the present appeal from order, considering its narrow compliance under Order 43. So thereafter, in paragraph 38, seen in light of the aforesaid settled proposition of law, we are of the clear view that in the facts of the present case, the High Court overstepped its appellate jurisdiction under Order 43 of the CPC and substituted its own view for the one taken by the trial court without giving any categorical finding as to why the order of the trial court could be said to suffer from perversity, capriciousness, arbitrariness, mala fide, or having been passed in accordance of the settled principles governing the grant of injunction under Order 39 of the CPC. Then, sir, paragraph number 43. Sir, before that, sorry, paragraph 36. Paragraph 36. Where the Honorable Supreme Court refers to various definitions.
The expression perverse has been defined by
Yeah.
various dictionaries.
The definition of perversity, perverse, is taken note of from various dictionaries. I will not trouble your honor with the reading of each definition, because ultimately in paragraph 43, the Honorable Supreme Court has concluded as to what it would like to attribute by way of a meaning to the word perversity. Paragraph 40. It is also pertinent. Sir, I'll just, 1 minute, sir, I'll just send one message to the High Court. Just a because I have to just request my. Okay, sir. Sir, paragraph 43. It is also pertinent to observe that immediately after the High Court set aside the order of the trial court, granting entering injunction.
Sir, please wait.
Number, sir, paragraph 40.
Mr. David,
Sorry. I'm sorry. Yeah, sorry. I just.
the judge has
I'm
gone
sorry.
into his chambers for 2 minutes. Please wait.
I missed noticing it. Sorry. We can also have a break.
Continue.
Yes, sir. Sir, I was reading paragraph 43.
Yes, yes.
Sir, paragraph 43, the apprehension which I voiced, sir, when I was dealing with my first submission, that this stay cannot be granted. Sir, I said if a stay is granted, what would happen? They will go ahead with the transaction with the other party, and it would lead to multiplicity of proceedings, virtually jeopardize my right in the present appeal. Now, in paragraph 43, the Honorable Supreme Court echoed the same thing. It is also pertinent to observe that immediately after the High Court set aside the order of the trial court granting interim injunction, the defendant number 3 entered into a transaction which created a third party right on the suit property. A perusal of the impugned order indicates that although a specific request was made by the plaintiff before the High Court to stay the operation of the impugned order to enable to file an appeal before this court, yet the request was not accepted. It is beyond our comprehension as to why such urgency was exhibited by the High Court in vacating the status quo on the suit property, more so when the suit was still pending before the trial court and the rights of the parties were yet to be crystallized. The sequence in which events have transpired in the present case best illustrates how the exercise of appellate jurisdiction by the High Court in a casual manner can have cascading effect which only prolong litigation and counter serve the interest of justice. Then, sir, ultimately, the Honorable Supreme Court, I was referring to that definition part, where in paragraph 37, the Honorable Supreme Court says what it would meant by perversity. So again, if we turn to paragraph 36. And in there are about 6 or 7 definitions of perversity have been referred to. And thereafter in paragraph 37, which I read with your honor, but I would like to emphasize with your honor's permission, though by way of repetition, the conclusion ultimately reached by the Honorable Supreme Court on the issue of perversity. The wrong finding should stem out on a complete misreading of evidence or should be based only on conjecture and surmises. Safest approach on perversity is classic approach on reasonable man's interference on the facts, meaning by which no man of reasonable prudence would ever come to a conclusion which the trial court has reached on appreciation of the evidence. Then only the finding can be said to be perverse. Meaning by which, if the trial court ignores the evidence on the record completely and disagrees on the proposal that 1 is to 1 is equal to 2, if trial court says no, I would say 1 plus 1 is equal to 3, that is called perversity. See, if I have to illustrate what the Honorable Supreme Court has said in paragraph 37 by giving an example. If the court says, no, I don't agree, 1 plus 1 is not 2, it is 3 or 4, it is called perversity because no man of reasonable prudence would ever say. Here, trial court says, I look at the correspondence and I come to a particular conclusion, which is equally possible. Whether it is right or wrong is not the present stage. It is to be decided now finally when the suit is taken up for hearing. So, in my respectful submission, when this is the scope of the present appeal from order, where at the stage of final hearing of the appeal from order, your honor would not be in a position to sit in judgment or in appeal over the finding of fact recorded by the trial court. So where is the question of permitting the present appellant to request your honor to stay the impugned judgment and order, ignoring the well-reasoned finding of fact recorded by the trial. Now, sir, still further, in order to spell out scope for, I have to say, in order to remove the scope for any doubt that this judgment would not qualify as a perverse judgment in eye of law. Sir, I would like to invite attention of the Honorable Court to the impugned judgment. Sir, page 17 of the paper is the impugned judgment. Sir, reasoning would start from paragraph 9 on page 23.
Yes.
Sir, at present, I am not taking your honor in details to the merits of the contention, which I will do it later. At present, I am trying to drive home the point that the conclusion which the trial court has reached is after taking into consideration rival contentions, documentary evidence on the record, and taking one view of the matter, which is equally possible. So paragraph 9, reasons would start, and it records the rival contentions. To save the time of the Honorable Court, I would like to turn to paragraph number 14 in the first instance, 11 in the first instance, where a finding is recorded. Till then, paragraph 9 and 10, the trial court discusses the documentary evidence. Now, finding is recorded. So, looking to all above mentioned correspondence, meaning by which everything on the record is taken note of. This court comes to a conclusion that a plaintiff proceeding with every stage of the process of proposed acquisition with a reasonable expectation of being successful. Indicative offer and final offer of the plaintiff were accepted as well as acted upon by the defendant. The plaintiff was and is ready to increase offer and bridge any gaps in his offer and expected valuation by writing various emails, which are all received to PwC, that is PricewaterhouseCoopers. That is not disputed. The plaintiff informed PwC that we have confirmed the enterprise value of euro 369 million and also confirmed to be able to increase equity value to euro 90 million. The defendants were responding to each communication. It is true that defendant did not accept the terms and conditions sent by the plaintiff in writing. However, defendant did not object any condition, particularly break-free clause, which is mentioned in the final offer of the plaintiff. Even if emails correspondence which are on record was treated as counter offer, that stands accepted by silence of the defendant number 3, as acceptance can also be implied from conduct of the parties. So trial court records its reasoning, which is a possible view, permissible view. There is a paragraph 12. Sorry, paragraph 12 I can skip. Paragraph 13. Before discussion for case law, I would like to mention that it is a duty of the court to arrive at a conclusion whether there was any meeting of mind between the parties which would create a binding contract between them. Therefore, even if documents produced by the plaintiff not signed by the parties, that would not a ground to disbelieve any party. A contract may be spelled out from the correspondence and interaction between the parties. So it's a subtle proposition of law. The contract need not be always in writing. It could be culled out by the conduct of the party, from the correspondence between the parties. And trial could record that finding. How that finding in my respectful submission can be said to be perverse in nature. So thereafter in paragraph 16, learned advocate for defendant number 1 relied 4 judgment mentioned herein above in para 4 on the subject of concluded contract and acceptance must be absolute and conditional and formation of the contract, etc. This court firmly believes by sending emails and correspondence by both the parties, there was meeting of mind between the parties which would create a binding contract between them. Therefore, I am not inclined to uphold the argument of the London Council for the defendant number 1. Another judgment which has been relied upon by the London Council for defendant number 1 can hardly be of any assistance to him when, after thorough reading of the document submitted by the plaintiff, this court is satisfied that the plaintiff has established a prima facie case for the relief sought in the interim application. The document sought to be done by the plaintiff clearly indicate that there was meeting of mind between the parties and also exchange various emails for takeover of the disputed property. Sir, in my respectful submission, contract means meeting of mind. What is contract ultimately? Offer by one party, acceptance by the other party, meaning by which both the parties are ad idem on one issue. That's known as contract. Trial court refers to the concept of contract. Says that yes, defendant number 1, present appellant, was insisting there is no written contract, no signed contract. The trial court says, but from your correspondence, from your emails, meeting of mind on the offer submitted by the present plaintiff, response number 1, is very much evident. That offer stand accepted, I can make out. Signing of a contract thereafter being a formality. Sir, in my respectful submission, how this view can be said to be a view which no man of reasonable prudence would ever take so as to call out a perverse view as held by Justice Padiwala in the recent judgment of the Honorable Supreme Court. Their perversity means no man of reasonable prudence would ever come to that. Here, this view is equally possible. And again, at the expense of reputation, whether view is right or wrong is not to be decided at this stage. It is to be decided only when the suit is taken up for the final disposal, when the evidence is laid. Today, in appeal from order under Order 43, the limited scope is whether it is a possible view or not. If it is a possible view, it's not a perverse view. If it is not a perverse view, it cannot be interfered with in appeal from order. If it cannot be interfered with in appeal from order, finally, in my respectful submission, for stay application, it can never be interfered with and they cannot seek any stay of the impugned judgment at all. With this, sir, I would like to turn to, after recess, sir, my second.
Just like a doorway. Meanwhile, you clarify on these 2 points. First, take the jurisdiction part.
Jurisdiction.
German jurisdiction, German Frankfurt में jurisdiction છે આમાં લોકોનું જે
હા હું સાહેબ આવું છું.
main claim એ છે અને બીજું the shareholders are also not parties.
I'll come to that, sir.
Court has granted the stay against the shareholders.
I'm aware about that. I'm aware about that, sir. I'm aware about that. And in that I'll deal with. So next.
આપણે 245 એ રાખીએ.
Sir, 3 o'clock, sir, or 2:45.
245 will be
2:45. Sir, 2:45.
સુપારકર ભાઈ તમે
સાહેબ હું આગળ પાછળ હોઈશ તો માય ફ્રેન્ડ મિસ્ટર કુપર ઇઝ ધેર માય
Cooper is there, no
ક્લાયન્ટ્સ આર ધેર 245 ચાલુ કરી દઈએ મારા માટે તો કોઈ જરૂર
245 ચાલુ કરી દઈએ આપણે.
હાજી.
May I only request Mr. Dave to indicate, is he likely to finish today?
Possibly not. Because I have got at 4 o'clock, subject to objection of Mr. Soparkar, because permission of the Honorable Court, I will place later on. First, Soparkar's objection. Sir, I have got a 4 o'clock fixed matter. Before the Honorable High Court, I am trying to.
This is
If Mr. Soparkar can buy an
permission,
adjournment for me.
Sir,
this
if you are
becomes
seeking my permission, I am
impossible.
not giving.
No, I request Mr. Soparkar to buy an adjournment for me. Then I would like to continue in 4 o'clock.
We would have an objection, but anyway, that's you as an.
I am trying, so I'm just lightly, I'm trying to get that matter. In case of at 4:30, I will have to.
કઈ કોર્ટમાં છે કનું કરાવડાવેલું?
Justice Mahini court.
કરાવડાવી લઈએ ચાલો.
I know you can rule the High Court, sir.
Sir, I'll beg on
But
your
I will not
behalf,
permit
sir.
you to rule here.
Sir, I
I
will
will not
beg on
permit
your
you to
behalf,
rule.
sir. Okay.
If we can go on at least, if we can go on till at least close to 5 o'clock, then there's something rather than stop
No,
at 4
Honorable
o'clock.
Court said right up to 5:30, Mr. Cooper. So
No, 5 o'clock. 5 o'clock, I'll be exhausted by that.
At least 5 o'clock, 5:30.
5 o'clock, yes.
5
I'm
o'clock.
I'm
rather than-
trying to get that matter at here. If feeling which, in case of difficulty, I may request for couple of minutes break or something of that sort.
Okay, we meet at quarter to
45
Quarter to 5, 2:45.
શું હતું તમારે?
સિરિયલ નંબર 8 આગોતરામાં વિડ્રો પ્રોસેસ
એન્ટિસિપેટરી બિલ છે
જી સર
વિડ્રો કરો છો
જી સર. તમારે શું છે પટેલભાઈ તમારા સિરિયલ નંબર 7 માં
કરી દે છે arrangement આજે કરવાની છે તમારે કે ના આજે નિશ્ચય છે રાખવાનું પૂછ્યું મેં, બરાબર 15/4 રાખવાનું 15/4 આપણે 2:45 વાગે હે ને? તમે ધવલભાઈ ના જજમેન્ટ લઈને આવ્યા છો બધા
સર અમારા પાસે તો નહીં હોય ને કકડ સાહેબ પાસે
અચ્છા એ આવવાનું હા ધવલભાઈ
શરૂ કરો સાહેબ. I can start. So, sir, at the first half, I made my submissions on two propositions. Number one, this being hearing in respect of a stay application, stay of a prohibitory preventive interim order requiring the parties to maintain status quo can never be granted, pending final disposal of the appeal. And number two, I argued about assuming that this kind of stay application they can place into service. Then also considering the scope of Order 43, there is no question of granting. Now I'm on a third point. Now, sir, there is one important aspect of this appeal. Sir, order passed by the trial court,
yes
the interim order which is impugned in this appeal, prevents all defendants, defendant number 1, 2, 3, and 4,
yes
and directs all of them to maintain status quo.
yes
However, the present appeal is filed only by defendant number 1. The rest of the defendants have not preferred to file the appeal, meaning by which they have subscribed to the appeal, one can say so. But sir, there is another aspect for which they appear to have not chosen to file an appeal, because injunction application filed under Order 39 by the plaintiff, respondent number 1 in the present appeal, was opposed by filing reply by only defendant number 1, the present appellant. So reply, because once an injunction application is filed, if you want to contest the injunction application, you need to file your reply in respect of the same. If you look at the record, page 580 of the paper book, Exhibit 9, the paper book which they have submitted, page 580, would clearly indicate Sir, page 580, it's an exhibit 9 in the trial court. Reply to the application for interim injunction under so and so of the Code of Civil Procedure, and it is filed in my respectful submission by only present appellant, defendant number 1, which is very much evident from paragraph 2 of that application. At the outset, defendant number 1 denies. Even reply, nowhere it is mentioned that it is filed for and behalf of all the defendants. It is only for and behalf of defendant number 1. The resultant effect is that so far as defendants number 2, 3, and 4 are concerned, there is no contest to the injunction application on merits. and presumably on account of that factor only, the rest of the defendants have not preferred any appeal before your honor challenging the order. To what extent the other defendants who are respondents here in this appeal can support the appellant is a different issue.
Defendant number 2, 3, and 4 are a subsidiary company of defendant number 1.
So defendant number 2 is a subsidiary company. Defendant number 2. Number 3 and 4 are the shareholders, according to us, or persons representing the shareholders. Sir, there is a dispute whether they are shareholders or not, but nonetheless, the record would reveal that all throughout in the transaction, they were representing themselves for and behalf of the shareholders of defendant number 1. But the point to be emphasized is defendant number 1 is making hue and cry in the present appeal by projecting a German company unnecessarily being dragged into litigation, and all defendants have been injuncted. But my submission is, where is the reply of defendants number 2, 3, and 4 opposing the injunction application? So if you look at the impugn order, that with profound respect, learned trial judge has rightly recorded submissions of defendant number 1 alone in respect of the interim injunction application. Because interim injunction application can be said to have been opposed by filing reply only by the present appellant and not rest of the defendants. Now, what the rest of the defendants did? So they, defendant number 2 on one hand and defendant number 3 and 4 on the other, gave 2 applications under Order 1, Rule 10, seeking deletion of their names as defendants. One application was given by defendant number 2 under Order 1, Rule 10. Another application was given by defendant number 3 and 4 jointly under Order 1, Rule 10, seeking the deletion. And your honor would find that application, I'll just point out. That application is there on the record. I'll just, within a moment, I'll give the page number. Sir, page 633. 633 may be seen.
Exhibit 27.
Yes, Exhibit 27, 633. This is an application under Order 1, Rule 10 by defendant number 2. And so far as defendant number 3 and 4 are concerned, the application is, I'll just point out that page just to complete the record and then I move further. Sir, he is on page there is a after amendment. I think that they have not put on the record by the paper book, it seems. That application is not there. Number 3 and 4 the applications. No, that application appears to be not placed on record. But sir, it's a, I can make a statement. It's an that application was moved also by defendants number 3 and 4 under Order 1, Rule 10. Since the original record is not with your honor, we are banking only on the paper book. The paper book seems to have not placed on record. Your index or paper book. No. But sir, I can make a statement that Order 1, Rule 10, similar application was given by different number 3 and 4. Now, sir, my submission is, therefore, the present appeal is required to be construed only by different number 1 being aggrieved by the impugned judgment and order. The rest of the defendants, sir, in my respectful submission, so far as injunction qua rest of the defendant is concerned, having not contested the interim injunction application in the suit by filing a reply, and consequently having no right to challenge the order, impugned order, in my respectful submission, they cannot support the present appeal of the appellants. Subject to what they have to say about their right, sir, I reserve my right to make further submission on that. For the time being, I would like to put an end to this submission by mentioning that injunction application was contested only by the present appellant, different number 1. The rest were contended with filing order 1 rule 10 application for deletion of their name, which was rejected by the trial court, and against which they have not preferred any proceedings. Now, sir, with this important aspect, I move further on the submission that the trial court was absolutely justified in coming to a conclusion that there was a concluded contract. Because, sir, my second submission was regarding the scope of the appeal. I said that once a finding is recorded, it cannot be upset. But I said move further. I said without prejudice by that submission, let us examine whether finding recorded by the trial court on appreciation of the evidence on the record can be said to be a possible one or not, so as to say that it is not perverse in nature. Because up till now I mentioned what is perversity. Honorable Supreme Court says perversity means you come to a conclusion without looking at the evidence at all. Or you look at the evidence and come to a conclusion which no man of reasonable prudence would ever come. It is just like 1 + 1 = 2. No, I don't agree. Therefore, now I am to point out without prejudice my second submission, that even if the view taken by the trial court is to be examined on merits, the trial court was entitled to have that conclusion that there was a concluded contract as a possible view of the matter. Now, for that, the first submission is, it is not necessary in law always to have a written contract unless it is the requirement of some statute. Indian Contract Act never provides that a particular contract has to be in writing. It could be the requirement of some other statute governing the relationship between the parties. Say, for example, lease deed. Lease deed is ultimately a contract between the parties. Transfer of Property Act requires registration and writing of a lease deed as must. Therefore, it is required to be reduced to writing. But there is no such requirement so far as contract of the nature which we are having on hand is concerned. There is no statute. It is not even the case of the appellant that such kind of contract is required to be reduced to writing in order to arrive at the contract. Therefore, in a situation where the contract is not governed by any statutory requirement and purely governed by the provisions of the Indian Contract Act, such contract can be culled out from the conduct of the parties, from the correspondence exchange between the parties. And for that, I would like to rely upon the judgment of the Honorable Supreme Court in the matter of Gobind Rubber Limited reported in 2015, volume 13, Supreme Court cases 477. I'm requesting Kavya, if you can issue there, to screen share with the Honorable Court. She's there. So within a moment, she's screen sharing. Unfortunately, sir, our instructing advocate in Valsad appears to be held up in some court. Otherwise, all physical judgments. But I'll see that by the end of the day, sir, you get all.
Yes, no problem.
I'm sorry for the inconvenience, but now, sir, paragraph 12 of this judgment BBC. There may not be any dispute with regard to the settled proposition of law that an agreement, even if not signed by the parties, can be spelled out from correspondence exchange between the parties. However, if it is a duty of the court to consider correspondence with a view to arrive at the conclusion whether there was any meeting of mind between the parties which could create a binding contract between them, it is necessary for the court to find out from the correspondence as to whether parties were ad idem to the terms of the contract. So Supreme Court is very clear that a contract can be culled out from the correspondence between the parties, and for the purpose of culling out the contract from correspondence and conduct of the parties, the trial court has to ascertain as to whether there is meeting of mind or not, whether parties are ad idem or not. And this is what exactly the trial court has done. I have taken your honor in the first session to the relevant observation in the impugned judgment, where trial court records a finding that yes, having looked at the correspondence, I come to a conclusion there is a meeting of mind between the parties. Offer was accepted by the present defendants. That's what the Honorable Court has recorded. Now, the second judgment on which I would like to place reliance is a judgment in the matter of Indowind Energy Limited, 2010, 5 SCC 306, paragraph 20. I repeat, sir, 2010, volume 5, SCC 306, and relevant paragraph is paragraph 20. Kaya, please screen share with the Honorable Court the judgment. Now, sir, paragraph 20. Whisker, that is one of the parties, refer to several acts and transactions as also conduct of Indowind to contend that an inference should be drawn that Indowind was a party to the agreement, or that it had affirmed and approved the agreement or acted in terms of the agreement. An examination of transaction between the parties to decide whether there is a valid contract, or whether a particular party owed any obligation towards another party, or whether any person had committed breach of the contract, will be possible in a suit or arbitration proceeding claiming damages or performance. But the issue is in the proceeding under section 11 is not whether there was any contract between the parties or any breach. A contract can be entered into. Now, this is the clinching line. A contract can be entered into even orally. A contract can be spelled out from the correspondence or conduct. But an arbitration agreement, there is no effects of the case. So again, the Honorable Supreme Court reiterated in Indowind's case that contract could be oral, it could be culled out from the correspondence between the parties. The third judgment throwing light on this aspect is in the matter of Rickmer's 1999, Volume 1, SCC, page 1. Paragraph 12 would be relevant paragraph. Kavya, shall I repeat the citation? 1999, 1 SCC, page 1. If it is not there with you, then I can move further.
So can you just repeat the name?
Yeah. 1999, 1 SCC, volume 1, Rickmer's case. Should I? Chetan, yes. Come in. Doesn't screen share. Kavya Jayas. Double click. हाँ. क्या करूँ? मैंने करूँ. Sir, paragraph 12. Again, the Honorable Supreme Court was confronted with the situation as to whether a contract can be culled out from correspondence or not. The submission of Mr. Nariman that an agreement, even if not signed by the parties, can be spelt out from the correspondent exchange between the parties admits of no doubt. In fact, various judgments cited by him at the bar unmistakably support this assertion. The question, however, is, can any agreement be spelled out from the correspondence between the parties in the instant case? In this connection, the cardinal principle, next paragraph, 13, to remember is that it is the duty of the court to construe correspondence with a view to arrive at a conclusion whether there was any meeting of mind between the parties which could create a binding contract between them. But the court is not empowered to create a contract for the parties by going outside the clear language used in the correspondence, except insofar as there are some appropriate application of law to be drawn. Unless from the correspondence it can unequivocally and clear even there are parties where an ad item to the terms, it cannot be said that an agreement had come into existence between the parties. The court is required to review what parties wrote and how they acted, and from that material to infer whether intention as expressed in the correspondence was to bring into existence mutually binding contract. The intention of the parties is to be gathered only from the expression used in the correspondence and the meaning it conveys. And in case it shows that there has been a meeting of mind between the parties, they had actually reached an agreement upon all material terms, then and then alone can be said that a binding contract is capable of being spelled out from the correspondence. So what the trial court did was within its jurisdiction. Because that, so far as prison appeal is concerned, we are more concerned with, because its finding can be interfered with if it is found to be perverse, capricious, or arbitrary. Perverse means without considering the evidence, or considering the evidence in a manner which no man of reasonable prudence would ever consider. Here in this case, correspondence has been considered by the trial court, which is permissible in law, with the Honorable Supreme Court says. Then there is a third judgment. And then I go to the facts of the case. Third judgment is in the matter of state of Tamil Nadu versus Srinivas, 1996, 10 SCC, 648. (1996), 10 SCC, 648. And this is more appropriate to our fact situation. Can you read? 1996 10 SCC. Thank you. Sir, turn to paragraph 50. Paragraph 50. As stated earlier, in the foregoing paras of this judgment, the coupon of the company is sold to the customer A on payment of ₹5. Whereafter, the customer A receives 3 coupons for ₹16, which he sells to 3 persons for ₹5 each, and appropriates the amount so received by himself. When each of 3 parties to whom the coupons are sold by A further sell their coupons to others, namely B, C, and D, one cycle is completed, and the customer A in turn receives the article of his choice as mentioned by him in the coupon from the company. In the process stated earlier, the company dispatches a letter to his customer A advising him to sell the 3 order forms to 3 members and take that money himself. Not only this, SSC company further addresses a letter to customer A in the printed form conveying that thanks to him and that they have received 3 original orders from, and the letter stating further that as soon as VPL are cleared by paying ₹16, they will send him to the required article. Thereafter, the company ultimately dispatches the article of his choice to the customer A with a covering letter advising him to receive the article by paying the settled amount. Now comes the material point. From these facts, it is clear that there may not be a formal contract for sale and purchase of article in any specific form, but such a contract may be spelled out from the correspondence and interaction between the parties. In the instant case, an implied contract between the parties is spelled out from the correspondence and interaction between the parties. In the present case, an implied contract between the parties is spelled out when the company offers the coupon against the payment and the article of the choice is ultimately sent to the customer for payment of price, which is accepted by the Commonwealth. There is thus offer and acceptance if the contents of the entire scheme that would be on the facts of the case. So I'm skipping it. So here again, purely, there was nothing, purely correspondence, conduct of the parties. The Honorable Supreme Court says, yes, it is possible to call out a contract. Therefore, with these 3 judgments, my submission is the trial court was absolutely within its jurisdiction in coming to a conclusion that a contract, though not written, can be culled out from the correspondence between the parties because it is a permissible proposition in law. Now, with this proposition of law, if we turn to the facts of the case on hand, sir, it will become evident that not only the trial court was having a jurisdiction to cull out a contract, but it had been rightly culled out from the correspondence between the parties. And for that purpose, I would like to refer to the facts of the case. Sir, before I turn to the facts of the case, I would like to say that give brief description of the parties. Different number 1 the present Apple is a German company. Different number 2 is an Indian company, which is a wholly owned subsidiary of different number 1, the present Apple, having area of operation within the territorial jurisdiction of the concerned civil court at Vapi. Different number 3 and 4, according to the plaintiff, are the shareholders of different number 1. Different number 1 is disputing that, saying that they are not the shareholders without disclosing who the shareholders are. Be that as it may, the evidence on the record, the correspondence between the parties would go to indicate that different number 3 and 4 were representing defendant number 1 and its shareholders. With this backdrop, sir, I turn to the factual metrics of the case. Sir, an agency called Price Waterhouse Coopers, that is known as PwC in short, was appointed by the shareholders of different number 1, the present appellant, for working out with suitable entity the entire divesting of their shareholding in different number 1. And pursuant to its appointment by the shareholders of different number 1, the present appellant, on 3rd June 2024, PwC addressed an email to the present plaintiff, which your honor would find in the list of in the paper book. There is a I'll just point out the page. Just a moment, I will point out the paper book page. Paper book. So there is a in the paper book, they have said after the impugn order, rather, that I'll just point out from a paper book. Because unfortunately, my marking is in the original record before the trial court. Now there is a paper book submitted here.
PKU offers, my PwC.
Sir, 3rd June નો સાહેબ email છે.
Process letter 1 કરી.
3rd June 2014. સાહેબ internal page 2 હશે સાહેબ એનું.
3rd June 2024.
ત્યાં સાહેબ એનાથી આગળ વાંધો નહીં આવે. સાહેબ there's an invitation to offer.
Private and confidential on the top left.
Yes, private and confidential. That, sir, by this email, PwC, the agency appointed by the shareholders of different number 1, the present appellant, sent an invitation to the plaintiff to submit its offer. Sir, contents are worth noting. The title is Process Letter 1, Project Roadrunner. Thank you for your interest in Project Roadrunner and returning the signed confidentially agreement. Price Waterhouse Coopers, GmbH, that is so and so, hereinafter referred to as PwC, there is that short name, has been mandated as sole M&A, merger and acquisition advisor, by the shareholders, the vendors, with regard to the intended disputed disposal of 100% of their ownership of shares in different, that MHM Holding GmbH, there is different number 1, to direct and to direct the indirect subsidiaries together, Huber Group or the company hereinafter referred to as the transaction or Project Roadrunner, please refer to the interlocutory information memorandum for a more detailed overview of the transaction scope and envisaged transaction structure. We are pleased to invite you to participate in phase 1 of the project Road Runner. The purpose of this letter is to outline the basic structure and key elements that should be considered in your offer for Huber Group and set out the process that you are expected to follow with respect to the transaction. Your offer shall be based on information provided in the attached information memorandum. So this is the starting point. On 3rd June, agent of the shareholders of different number 1 invited plaintiff to submit its offer, and the project was named as Project Roadrunner, the entire process, and this was considered as process letter number 1. The relevant condition on next page. The following paragraphs outline details of the first phase of the process. So relevant condition number 1, you are invited to submit an indicative offer for the company on the basis of information contained in the information memorandum no later than 5 p.m. CET, there is Central European Time, on 4th June 2010. And the other relevant condition in this is condition number 2, next steps. A number of parties who have submitted indicative offer may then be invited to participate in phase 2 of the process, which involves then further steps. We are not concerned with that. The invitation to any of the above mentioned step is as vendor's sole discretion. And then the clause on which the other side is placing high degree of reliance. Nothing in this letter, that is on, sir, last page, or rather page number 7. Nothing in this letter shall create any binding obligation, including, for example, any obligation to enter into any agreement on the vendors or PwC in particular. Neither this letter nor the release of information memorandum or any other information shall constitute an offer to sell or an invitation to purchase or tender of the company or any its business shareholding assets. By submitting the indicative offer, you confirm your full understanding of an agreement with and terms and conditions set out herein. Then the last condition, this letter shall be governed. Your Honor may mark the word this letter. What is these letter shall be governed by and construed in accordance with German law, including its conflict of laws provisions, and you hereby irrevocably submit to the exclusive jurisdiction of the court of Frankfurt at Main, Germany. Now, therefore, by this communication, an invitation was sent, number 1, to the plaintiff to submit its indicative offer with the rider that if your indicative offer is found to be acceptable to us, you will be permitted to enter phase number 2 of this project Roadrunner. The project was for divesting the entire shareholding of different number 1 the appellant, for which PwC was appointed as an agent by the shareholders of different number 1. Indicative offer is told, and at the end it is said that this is an indicative offer, we are inviting you. This invitation will not create any right upon you. This will only permit you to submit your indicative offer, and if that offer is found to be acceptable to us, you will be permitted to enter phase 2 of the present project, and the clause with regard to jurisdiction of the courts at Germany was restricted to these later. This language is very clear. These later shall be governed. Meaning by which, if there is any dispute with regard to this invitation to offer, then the courts at Germany would have a jurisdiction. It nowhere states that anything and everything which may happen hereafter would also be governed by the courts at Germany. This is restricted only to this particular letter, which was nothing but an invitation to submit an indicative offer, which was considered as part 1 or process 1, phase 1 of the project. After this invitation from PwC, the present plaintiff submitted its offer on 14th June 2024, which your honor would find page 172. Page 172 of the paper. It's 14th June. Am I with your honor?
Yes, yes. From
14th June 2024. Now, the relevant is on the first, read the first line. Many thanks for sharing Project Roadrunner with us. Please see enclosed our non-binding offer. Kindly acknowledge receipt. We are available for any clarification. So we say that we are submitting our offer. We have accepted your invitation. Plaintiff is submitting its offer. It's a non-binding offer where we are at the initial stage. So we said this offer is a non-binding offer, meaning by which, so what is, because lot was said, as I am told, I am instructed by Mr. Soparkar during the course of his submission on this phrase non-binding. Sir, non-binding offer means till our offer is accepted, we have every right to withdraw this offer. Sir, even if we were not to mention this non-binding nature of the offer, under the Contract Act, person making the offer has every right to withdraw the offer before it is accepted. It is for the purpose of safeguarding our interest to withdraw the offer before it is accepted, which is otherwise permissible in law. So nothing turns against us on this non-binding nature of the offer. Then, sir, further, the relevant condition of this our offer. Sir, if we turn, if your honor turns to page, internal page, clause G, exclusivity. So there is a clause starting with clause 2, and I would like to turn to clause G, exclusivity, which is page number I just mentioned.
175.
170. I am obliged, sir, because my paging is differing from the
Yes.
exclusivity. On acceptance of our indicative offer, we should also need a confirmation that no other Indian company, there is company whose ultimate ownership is in India, moving to the next stage of the transaction, that is post indicative offer submission. So what we said, first of all, what I missed is our offer. So if your honor is turning to clause 2 page before that, but I have to mention our offer price also.
Ah, 360 billion. Million.
So our offer, proposed terms, the key terms of our indicative offer to the transaction are as below. So we submitted 360 euro million. Euro 360 million was our indicative offer. And that offer was subject to a rider, which I read on page, that we wanted them, that if this indicative offer is acceptable to you, then you should assure us that you would not be negotiating with any other Indian company. That's what we wanted as our condition to the offer. So after we submitted this offer, in this offer we also pointed in clause M that validity of this offer is for 7 days. We request you to send your countersigned copy on or before June 21st, 2020.
Whether they have signed this copy, counter signed copy is there with you?
No, signed copy by them, sir. No, sir. They never, but that's the point, because it is a contention of the other side that this was never signed as a signed copy. But nonetheless, by their correspondence, they have accepted this. Sir, signed copy was proposed by us as one of the mode of accepting our offer. So, અમે એમ કહ્યું કે તમે એમની સાઇન કોપી મોકલાવો. આ માનો કે સાહેબ સાઇન કોપી મોકલાયા વગર એમને ઈમેલ થી કન્ફર્મ કંઈ કર્યું હોય તો who can take objection? I can take an objection. I can say કે ના મારે તો સાઇન કોપી જ જોઈએ છે. પણ મને જે રીતે એ લોકોએ એક્સેપ્ટ કર્યું એ મોડ પસંદ હોય, સ્વીકારે પાત્ર હોય, then different number 1 present appellant cannot raise an objection. So say for example, I give a simple example that I want to sell my house and I put an offer to Mr. B. They say, look, I would like to sell my house for rupees 1 crore. If price is acceptable to you, please send me a written confirmation. The intending purchaser, Mr. B, instead of sending a written confirmation, conveys to me telephonically or send a WhatsApp message. Now it is me who can object, saying that no, I want written confirmation. But if something other than the what I required him to do is done by that party, then if it is acceptable to me, the other side, the party who prefers that mode cannot object to it. Suppose payment is to be made, let us say, for submitting any bid to a tender floated by a government. So the offer is required to be submitted along with the security deposit. And security deposit is required to be given by way of a demand draft. And if I give a security deposit by way of a check, and if that check is accepted by the government, deposited, encashed, so can it be later on said that no, since you did not send demand security deposit by way of a demand draft, we will not consider your offer as valid? I preferred other mode, and that other mode is acceptable. So here also, and as I'll make good my submission, this indicative offer of ours was accepted by the agent of the shareholders of different number 1, namely PwC. Why? Because sir, what was the purpose of indicative offer? If our indicative offer was acceptable to them, they were required to take us to the second phase of the project, further negotiation. Now, if further negotiation takes place, if we are taken to the second phase of the project, in my respectful submission, our indicative offer was accepted by PwC for and behalf of the shareholders of different number 1, which would also bind the different number 1. And for that purpose, sir, I would take your honor to next correspondence email 14 June on the written by PwC 180 on email dated 14th June 2014. 2024. We hereby confirm, thanks for the offer letter, we hereby confirm receipt and will come back to you shortly for any question which may arise. So, on the very day on which we submitted our offer, our indicative offer of 360 euro million, on very that day, we received an email acknowledging the receipt of our offer. Thereafter, sir, on 8th July 2024, there is an email, next page, 181. This communication, this email would go to show that our indicative offer was accepted by them. And I'll make good that by reading the contents of this email. We come back to you, to your below email, and respective indicative offer. As already envisaged, we are pleased to grant you access to phase 2 of Project Roadrunner, giving you possibility to perform an in-depth due diligence. As you know, we are conducting a structured international merger and acquisition process for Huber Group. This implies transparent procedures and rules of the game for all participants. On the other hand, we are also obliged to keep confidentiality with regard to the process. The rest of the content would not be relevant for a present purpose, so I am skipping reading it. So what it says, the first invitation to offer. Invitation to offer called upon us on 3rd June to give indicative offer with a rider that this is phase 1. If your indicative offer is found to be acceptable to us, you will be taken to phase 2. Once we submit our indicative offer, we pointed out that you may confirm acceptance of our offer in writing by returning this communication duly signed by you. Instead of that, PwC chose to write an email saying that we are accepting your offer and we are taking you to phase 2. So the question of taking us to phase 2 of the process would arise, whereby we would have an access to their internal things. We can have due diligence. So that is possible if we are taken to phase 2 as per their original scheme of inviting us to offer. So we are taken to phase 2 by accepting our indicative offer. Sir, if we look again, the correspondence on 3rd June, it clearly mentioned that you will be taken to phase 2 if your indicative offer is found to be acceptable to us. And this communication clearly says, we are pleased to grant you your access to phase 2. Therefore, our indicative offer as submitted by us was acceptable to them. After this indicative offer were accepted by them, sir, on 8th July 2024, sir, the next stage, the next communication is 16 July 2024, page 182. A specific letter was issued to the plaintiff by PwC inviting to participate in phase 2 of the process and submit a final offer. It is addressed to Jindal plaintiff, subject process letter 2, Project Roadrunner. Thank you for your continued interest in Project Roadrunner. Based on your indicative offer letter and the following correspondence. We are pleased to inform you that Jindal Flexi Films Limited, there is plaintiff, has been selected to participate in phase 2 of Project Roller. The shareholders of MHM Holding, there is different number one, different number one shareholders. The vendor would like to invite you to personally meet the management and to perform due diligence with a view to submit a final offer. The final of to acquire up to 100% of shares in MHM Holding, there is different number one, and its direct and indirect subsidiaries, which would include different number two. The purpose of this letter is to outline the basic structure and key elements that should be considered in your final offer for the company, and to set out the process that you are expected to follow with respect to the transactions. And then in this communication, the another important point which is to be noted is no provision which we found in phase 1 of the letter saying that these letter shall be governed by German law and any dispute will be subject to the courts at Germany. One thing is very clear, sir, from this, that we were given an entry to phase 2 of the project. So even at the cost of reputation, when we were invited to offer, it was called phase 1 of the project. We were called upon to submit our indicative offer. In that phase 1 letter, two things were very relevant. That your indicative offer, if accepted, you will be permitted to enter phase 2 of the project. That letter said specific clause, this letter is governed by German law and any dispute will be covered by German. Thereafter, this communication which I just read of 16 July 2024 specifically says that you are now permitted to enter into phase 2 of the project. You are in phase 2 of the project. And you are called upon to give your final offer. Earlier was indicative offer. Here we are called upon to give our final offer. And the words used are, you are selected to participate in phase 2. I have very second paragraph this communication. It means we were through phase 1, we were in phase 2, and this letter was not having a clause which we find in the earlier communication, earlier letter about German jurisdiction. Now, sir, when we enter phase 2, we are governed by terms and conditions of this letter of phase 2. Now, sir, after this, there are certain exchange of emails between the parties in the month of July, August 2024, which I would like to skip to save the time of the Honorable Court. Now, material point is 30th August 2024 to 220, sir, page 220. Page 220. Till then, correspondence. Because we were in phase 2, we were permitted due diligence, interaction with PwC. Then page 220,
30th August email.
Yes, sir. 30th August 2024. I'm immensely obliged. So this is written by Jindal, that is plaintiff, to PwC, whereby the plaintiff submitted its first final offer for acquiring 100% shareholding of different number one, the present appellant, and the price quoted was 378 million euro. Earlier it was 360. It increased to 378. Relevant part of this communication, the very first line. Many thanks again for the opportunity to evaluate project Roadrunner. Please see enclose our final offer along with markup and clean version of SPA, that is share purchase agreement for project Roadrunner. Kindly acknowledge the receipt of this. We are available for any clarification. Not only we entered phase 2, but we submitted, because we were permitted to give our final offer, which we gave, and the offer is on the next page, written later, which was annexed to this, attached to this email of the same date. With reference to our non-binding offer letter dated 14th June 2024.
શાયદ રોલ ભાઈ આપણે પહેલા બી જોઈ લીધો છે 221 ના પેજ
સાહેબ હું સ્કીપ કરું આ
તમારો સ્કીપ કરો તો ઇમ્પોર્ટન્ટ રેલેવન્ટ પોઈન્ટ્સ કે હોય તો કહી દો બાકી we are having these on record.
Okay, I'll skip that. I'll skip.
But we
Then
have
my,
also
my submission is this, sir. Why I'm saying what is important? Sir, there will be some, because I am trying to drive home the point that a trial court has rightly come to a conclusion.
Yes.
That because though in my respectful submission, whether trial court is right in coming to a conclusion as to whether there is a concluded contract or not, cannot be examined in the limited scope of Order 43. Still, I am trying to bring home the point that the view taken by the trial court is not only a possible view, but is the only view on the basis of the correspondence on the record. If your honor says that I should not read in detail, I will not read in detail, but I will refer it to the relevant part only.
Yes, yes, definitely.
Now, sir, we are on this offer part. Clause number 2.
Your offer price was there 378 million.
378. Now, this is required to be read in conjunction with clause 2L on page 180. Just a one. On there is a clause called 2L.
Exclusivity.
224 exclusivity.
224.
Upon acceptance of this offer, Jindal would be provided with exclusivity for the transaction in order to conduct its confirmatory due diligence and negotiate and finalize the transaction document. During this exclusivity period, the seller and the company will discontinue all transaction discussion with any other interested parties and will not initiate any fresh discussion with any other potential buyer. The exclusivity will remain valid for a period of 60 days from the acceptance of the offer. So, while submitting our offer by increasing from 360 to 378, we put this rider. And rider was that once you accept our offer for a period of 60 days, we would like to have an exclusivity, meaning by which till we close the chapter, he will not simultaneously negotiate with any other bidder. That is what we wanted from him, which is known as exclusivity, meaning by which now you should not negotiate with any other person because we are at the advanced stage of the negotiation. Now, this communication of our offer of 30th August was responded by PwC on 6th September 2024 by writing an email to us. 6th September 2024 is on page 301. Is on page 301.
301.
Yes, there is very material, sir.
Yes.
This is 6th September 301. Now, by writing this communication, PwC responded to our first final offer by stating that it would not be possible to grant exclusivity qua negotiation as claimed by us, but they can give us signing exclusivity. Now, sir, this communication, very short one, second paragraph, as discussed, due to constraints imposed by the implemented trusteeship, we are unable to grant negotiation exclusivity in order to swiftly move towards a deal. Now, mark the words, sir. Why the trial court says there was meeting of mind. In order to swiftly move towards a deal, we suggest following procedure. The seller grants Jindal is signing exclusivity until 22nd of September. Then I skip two conditions. In addition, seller's lawyer and Jindal will have first negotiation round on share purchase agreement and start the WNI process in order to not losing time until the envisaged signing date 30th September 30th September. Should the offer not decrease, the seller will consider prolong the signing exclusivity until 30th September. If the proceeding above is acceptable for Jindal, we are hereby to provide quickly the draft exclusivity agreement for review. So, instead of rejecting our first final offer, they said that instead of giving you negotiation exclusivity, we would like to give you signing exclusivity for a period of 30 days, which we would like to extend also. And what is the difference between negotiation exclusivity and signing exclusivity? So negotiation exclusivity would mean till we are in the picture and till our offer is alive, they would not negotiate with any other person. Signing exclusivity would mean it would be open for them to negotiate with the third party, but without giving us the first chance, they would not go for signing of the contract with any other third party. So they say that yes, you have given 378 billion euros offer. We are happy with that. Now further things are required to be moved. We are prepared to move further swiftly, quickly to finalize the deal. We are also instructing our advocates, lawyers to negotiate with your lawyers to finalize share purchase agreement. Until then, we will not sign the contract with any other person. We give you signing exclusivity. So we move further with this. After this, sir, communication of 6 September 2024, where they substantially accepted our offer.
Sir, I
The
don't
next
want to
stage.
disturb my learned friend, but I have objection is reading documents in part. For example, page 301
I would like
last
to read them in
point.
entirety. Sir, I would like to read them in entirety. Honorable Court said that I should focus only on the relevant part.
But page 301 last sentence
I'll
I had
read.
said, okay, please continue. I don't want to
No,
make,
I'll read. I'll read.
I'll deal with it in my rejoinder.
No, I'll read. I'll complete it, sir. I was on document. Since Honorable Court indicated that I should only pinpoint the relevant part, I thought that I don't want to be accused of not reading something which is relevant. September 6, 2024 communication, I was reading it. My learned friend wants me to read the last line as I understand. Am I right, Mr. Sopar? You want me to read the...
Yes, sir. My case was we agreed with you that if this is acceptable to you, please let us know. So we will provide you with draft exclusivity agreement. You never agreed, and that agreement has never taken place.
That is, in my respectful submission, I read that particular part. Mr. Sopar can have every right to disagree with my interpretation. Ultimately, your honor will have to decide which interpretation is right. So I have not omitted reading which is relevant. Yes, my interpretation is you agreed to give us signing exclusivity and not negotiation activity. But the fact of the matter is that PwC categorically agreed to move ahead with our offer, that is of 378 euro, subject to this rider, and saying that we would like to quickly close the deal and we would like to instruct our lawyers to negotiate with your lawyers to finalize share purchase agreement. This is how, in my respectful submission, this communication is conveying, and accordingly it has been construed by the trial court also. Now, sir, I turn to the next communication, after the 6th of September, I turn to the next relevant communication is on 9th of September. On page, this is, we wrote, plaintiff wrote to PwC 303. We had a long discussion on the offer and the limitations that prevail at your end. Basis our final discussion, the attach is the absolute best terms we can offer. So when in the communication of 6th of September, PwC said that we cannot offer you negotiation exclusivity, but we can give you only signing exclusivity. We said that if that is so, and based upon our internal discussion, we would like to now revise our offer, and our best possible offer could be like this, and that we indicated immediately in the attached communication to this email. That is 9 September 2024 on the next page.
That is,
To
we have
that-
said to the respondent.
Please, next page, sir. Now, sir, there the relevant clause is clause 1, second paragraph. Because according to me, the first paragraph is not relevant. The group's flagship company in India, Jindal Polyfilm Limited, has available cash and cash equivalents in excess of euro 400 million as of March 31st, 2024. Enclosed copy as Appendix 2. We shall communicate the potential transaction through any of the existing or newly incorporated subsidiaries of, there is plaintiff, the buyer. So we, in this, pointed out that we have a financial credentials. We are showing the proof, we are attaching the proof in support thereof, and how the transaction will be carried out, that also we indicated that it will be either through the existing or newly incorporated subsidiary of the plaintiff. Then comes our offer in clause number 2 on the next page. The key term of our offer transaction are as follows. Based on further review, our enterprise value for the company on a debt-free, cash-free basis, along with normalized working capital required for a business of this scale, normalized working capital has been substantially increased to euro 369 billion. The increase in EV of euro 9 million from our earlier indicative offer dated 14 June 2024 should be read together with and subject to clause 2L breakup below. So posing for a moment here, with your honor's permission, 360 was our original indicative offer. First final offer with certain riders was 378. Major rider was negotiation exclusivity, which they were not prepared to grant. So we said, okay, now we are submitting our revised final offer, whereby we said that instead of 360 or 378, we will be offering 369. In this 369, euro 9 million is a breakup part of the offer, which is governed by clause 2L of this very offer, which your honor would find 2L on page 205, 305, 305, 307. Now, sir, what was that? 307. Upon acceptance of this offer, the seller agree to pay Jindal the following in case that no binding agreements in relation to the transaction are signed between Jindal and the seller on or before 31st October 2024. Euro 1 million in case transaction is not consummated by other party for any reason whatsoever. Euro 9 million in case the seller decides to consummate the transaction with any other party or not progress with the transaction after Jindal has confirmed their offer post confirmatory due diligence. So we said in this, sir, that look, we are now giving our final offer at 369 million euro, out of which 9 million euro is a break fee, meaning by which if this transaction is not through for any other reasons not attributable to either plaintiff or defendant number 1, for any other reason, then 1 billion euro will be paid to us by shareholders of defendant number 1. And if the transaction is not through, is broken on account of decision on the part of the shareholder defendant number 1 to go ahead with some other third party or just to drop the transaction with the plaintiff, then they will have to pay 9 million euro to us. So बहुत simple साहब हमें बात करी कि हमारी फिगर 369 એમાં 9 જે છે 9 મિલિયન યુરો એ બ્રેક ફી છે. જો આ ટ્રાન્ઝેક્શન કોઈ અગમ્ય કારણસર કે જેમાં નથી સામેવાળાનો વાંક કે અમારો વાંક એને કારણે થ્રુ ના થાય તો અમને 1 મિલિયન યુરો આપવાના ડેમેજીસના. અને જો તમે એટલે કે ડિફેન્ડન્ટ નંબર 1 any shareholders.
બીજા તમારી જોડે ટ્રાન્ઝેક્શન ફાઇનલ ના કરીને થર્ડ પાર્ટી જોડે કરે તો 9 billion.
But absolutely right. This is how our final offer was. Now, this offer, according to me, was accepted by them because this is of the date 6th September to 9th September 2024. And on 20th September 2024, 20th September 2024, page number 314. This is where the contract was concluded. 304. 9th September, 20th September 2020. So we wrote to them at 9th of September. And 31st October was pointed out in that as the outer limit for completing the transaction. In our 9th of September later. On 20th September, with thorough application of mine, PwC wrote to us, I hope this email finds you well. Many thanks again for your share purchase agreement markup on the project Roadrunner. Please find attached our counter markup prepared by so-and-so team in CC on this email. So, instead of saying that your offer of 9 September 2024 is not acceptable to us, they are thanking us and providing their version of share purchase agreement, offering comments on our version of share purchase agreement. Then next paragraph, as an immediate step, we would like to connect your legal advisor, DLA Pipe and Eversheds for them to organize a call and next steps, lawyers call, as they were not copied on our previous mail. It would be great if you could let us know who we can contact on DLA Piper side regarding share purchase agreement. Just forward our email to DLA with Eversheds and us in CC, and lawyers can organize the follow-up. Overall goal is to get to a meeting in the calendar as soon as possible, that is next Monday, to clarify and to explain certain changes and comments. In case of any question, please know. Sir, in my respectful submission, this is a document pursuant to which, or this is the communication pursuant to which the contract was concluded by accepting our offer of 6th September or 9th September 2020. And this is what the trial court has believed. And so contents are very indicative. If they were not to accept our offer, they could have said, we reject your offer. Instead of that, they say that now we would like your lawyers to interrogate with our lawyers. They go to the extent of saying that provide details of your lawyers. We would like to close the deal as early as possible. And minor changes required in share purchase agreement, for which we would like to have the meeting. Sir, in my respectful submission, this is the date on which the contract was concluded. And that is also indicative from the subsequent correspondence. If your honor takes the trouble of turning to subsequent events, which I'll quickly refer to. Sir, after this communication of 20th September 2024, in October 2024, the record would reveal, there was emails between the parties, meeting between the parties for finalizing the share purchase agreement. Then, sir, there is an email of 16th October 2024, which I can skip. It's formal one because there is any further. I'll just now go to the relevant one, which is, sir, 17th October 2024.
17th October.
17th October.
Yes. Page
409.
Yes.
Sir, this is, we wrote to PwC, Plaintiff wrote. We thank you for principals meeting an open discussion yesterday. As mentioned before, the BC Jindal Group is fully committed to completing the transaction for Huber Group at the enterprise value, which we have been shared with you in our offer dated 9th October. As you are aware, we have invested very significant time and resources in this project. We are confident that both the parties can achieve SPA signing in the coming days, and we can commit to making all resources available for SPA signing in this timeline. As discussed in yesterday's meeting, the following are the key principles for achieving signing in the coming days. And sir, then relevant terms and conditions have been mentioned. And after this, so we again showed that we would like to go ahead with signing the share purchase agreement. Sir, I am conscious of the fact the share purchase agreement was not formally signed. But sir, my respectful submission, signing of the share purchase agreement was not to evidence the contract. The factum of the contract is not to be culled out from a signing of the share purchase agreement. Factum of the contract is to be culled out from acceptance of our offer. Sir, signing of the share purchase agreement was sequel to, consequence to the contract. Sir, something which is required to be done as ancillary to the contract, that ancillary part cannot take the governing seat. Sir, contract થઈ ગયો. Contract થઈ ગયા પછીની જે formalities છે. મારી ઓફર એ લોકોએ એક્સેપ્ટ કરી. એ પછીની formalities શેર પરચેઝ એગ્રીમેન્ટ ફોર્મલી ડ્રો કરે. કે જે ટર્મ્સ અને કન્ડિશન્સ એગ્રી થયા છે એને આપણે રિડ્યુસ ટુ રાઇટિંગમાં મૂકીએ. પણ સાહેબ કોન્ટ્રાક્ટ થઈ ગયો. હવે એ કોન્ટ્રાક્ટ જે થઈ ગયો, એ કોન્ટ્રાક્ટમાંથી સાહેબ અત્યાર સુધી એક પણ એવી વાત નથી કરી એમને કે અમને તમારી ઓફર મંજૂર નથી and we would like to go ahead with some other party. On the contrary, share purchase agreement to draft finalize કેવી રીતે કરવું એ અંગેની સાહેબ વાટાઘાટો શરૂ થઈ ગઈ. Thereafter, after this communication of 17th of October, sir, on 22nd of October, 411, sir.
411.
411. Many thanks below. Am I with your honor?
Yes.
Many thanks below. So this is a email of 22nd October 2024. PwC wrote to us. Many thanks for your below email as well as ongoing discussion. We had over last weeks and months, as explained earlier on the phone, we are currently in discussion with the stakeholders on our end, mainly the banks, including the legal advisors and the shareholders. Given the complexity of the deal, as well as number of involved stakeholders, these unfortunately will take another few days. Thus, we ask again for your patience. We need to have a clear picture before we can take any decision regarding next steps. So what they say, have patience. signing of share purchase agreement, which is now the formality left, will take some time. They never said that our offer is not acceptable to us. Rather, we were advised to have a patience, because before signing the share purchase agreement, which would have many of the intricacies, which according to them involve concurrence of their stakeholders, which they are trying to work out, including their bankers. Not a whisper in this communication that your offer of 9 September, which we accepted on 20th of September, is not agreeable to us. So after this clear picture to us on 22nd October 2024, so 29th October 2000, 415.
415.
Yes. Sir, we wrote, rather on our behalf, PwC was called upon to update us about how and within what time the formality would be completed. We understand that there has been a delay in the process in order to seek waiver from lenders for an extension for Pipe Roadrunner, Project Roadrunner. Can you please update on the expected timeline and way forward? In addition, as you are aware, we are requested for the below expert call. Request if you can suggest time slots for this proposed expert call so that we can align all advisor and freeze calendars. So we pointed out to them that we understand difficulties at your end in getting things finalized for the purpose of signing of the share purchase agreement. But in the meantime, let us fix the calendar, timetable, and everything so that things can move further. So this is our response, to which nothing has been conveyed. Then no, there is no concluded contract with us. Don't go ahead. Sir, if my submission is that if I have to simply, instead of going by this language used by them, so let us try to visualize a practical situation. Sir, once a deal is done, say sale of an immovable property, well, ultimately this is a sale of a property. A sale of an immovable property is everything is finalized. Signing of a registered sale deed is a formality to be performed pursuant to the agreement you have to sell the property. Merely because signing of the registered sale deed is delayed on account of certain intervening factors, sir, can it be said that there is no contract to sell the property? Sir, in my respectful submission, the answer is no. Once the agreement is arrived at, the owner says that I would like to sell my property for price Y to B. Sir, contract is concluded. Sale deed is the formality to be performed pursuant to that particular contract. Merely because that formality is not performed, it cannot be said that contract was not arrived at. Contract was arrived at. Share purchase agreement was not the contract. Acceptance of our offer was the contract. Share purchase agreement was the formality to follow the contract which was arrived at. Now, after this 29th October email, by which we called upon them to expedite the things, their response is, let us see, 13 November 2024. In between emails, I am skipping it because according to me, nothing much turns on that. for the first time on 13th November 2024, 419. The concerned persons indicated their disinclination to go ahead now. And this, according to me, the starting point of the breach of the agreement. The breach, in my respectful submission, first breach took place on 13th November 2020. Thank you very much for your participation in the structure M&A process for the project Roadrunner. Upon consideration of relevant aspects of the competing offers in a particular transaction, security, equity purchase price, and clean exit concept, the trustees have finally made a decision in favor of another offer and have signed SPA with respective investor. So for the first time, it was indicated to the plaintiff that now we have changed our mind and we would like to sign share purchase agreement with another party. We would like to finalize the deal with another party. Moment we received this communication showing change of mind, total volte-face, sir, we immediately wrote to them on 13th November. This was followed by a press release on 13th of November on page 421. By this press release, they declared that they have decided to negotiate with another party named therein. So this was what was conveyed to us in the email, was confirmed by their press release on 13th November 2024. Since your honor is on this page, there is one important thing which is worth mentioning so far as this press release is concerned. Because during the course of the hearing, it was contended that defendant number 3 and 4 are least concerned with this transaction. They are not the shareholders. Sir, in this press release, the name of defendant number 3 specifically and categorically figures. If your honor refers to
Which is
very first paragraph.
page number કહું છું?
So page number is 421, press release.
421 ne?
421.
Okay.
It is a press release on 13th of November, informing the public at large that they are moving ahead with a consortium called MAVCO. Huber Group. Am I with your honor?
Huber Group, global leader in specialty chemicals.
Yes, yes. Huber Group, a global leader in specialty chemicals and print solution, is pleased to announce the signing of a sale and purchase agreement with consortium between MAVCO Investments, a private investment vehicle belonging to a select members of so-and-so family and fund managed by Avenue Capital Group, global investment firm. What is important is, sir, who is giving a declaration? Press release. Huber Group. That is defendant number 1. Huber Group, a global leader. This Huber Group would include defendant number 1 and defendant number 2. Defendant number 2 is a wholly owned subsidiary. Defendant number 1, the present appellant, is the lead company of the Huber Group. So they are announcing what? that we are entering into a sale of its shareholding with a consortium called Bavco. Now the next line is the consortium will acquire all shares in the company from the current owner. The name is Cornelius Tunen Holding. That is different number 3. Sir, we have gone by this press release and all throughout all our emails with PwC, majority of them were marked to this different number 3 and different number 4. Here name of different number 4 is missing, but different number 3's name is there. And all our emails were marked to both different number 3 and 4. So all throughout, including in the press release, which is by the Huber Group, which would include different number 1 and different number 2. Different number 3 and 4 are projected as the shareholders, or at least the person representing the shareholders of different number 1. And today, different number 1 is raising a grievance that they are not my shareholders without disclosing in that scenario who the shareholders are. Sir, be that as it may, I am on the point because this issue is separate, which I will deal with, but since your honor was on this page, I thought of referring to it. This is the way they declare to the public at large that they are going ahead with Mavco consortium and not with the plaintiff. Upon this, sir, we immediately wrote on 13th November in email. Page 423. Thanks for email. So we were surprised. We read enclosed article from Merger Market and we were surprised to see the numbers mentioned. We had confirmed the enterprise value of euro 369 million and also confirmed to be able to increase to equity value euro 90 million during multiple video and phone calls with you. Please let us know when we can talk. So we were surprised. So we said we would like to have a talk with you. This is what our email of 13th of November. And then 14th of November, we wrote this email to them, page 424. We have received the below tail mail and noted the content thereof. As you are aware, we have remained fully committed to the proposed transaction between the seller and Jindal, which is evident from the fact that we have periodically shared our offers and confirmations for the proposed transaction with you, which were duly acknowledged, accepted, and acted upon by you. Pertinently, our last offer, dated 9 September 2024, was accepted and acted upon by you. Further, towards the end of October 2024, basis your request, we increased our confirmed equity value to euro 90 million in the interest of closing the transaction. However, despite our confirmation, you decided to go ahead with some other entity. Therefore, we asked you to pay euro 9 million towards break fee as provided in the transaction document before 19th of November 2000. Please advise on any procedural formalities to complete this. This email is without prejudice to Jindal's rights and remedies, all of which are expressly reserved and waived. Meaning by which, without prejudice to our legal rights and contentions, our legal right to insist for specific performance of the contract which was arrived at, we said that this is not fair on your part. Now you are trying to back out. If so, first deposit 9 million euro, which was a break fee, because you are breaking the transaction. And this is without prejudice to all our legal rights and contentions. And after this, sir, in my respectful submission, since there was no positive response from
Four to five માં એ લોકોએ reply કર્યો છે.
Uh.
Your allegations and in particular claim.
Pardon, sir?
425 માં એ લોકા what you have claimed.
Yes, I will okay now. Your allegations and particular your claim for breakup are baseless. As you are aware, you were one bidder among several bidders in formal auction process. Your offer did not meet our expectation. That is why it was never accepted by us. Sir, sorry, I'll just take. Sir, all of the communications which I refer to, page 423, page 2024, everywhere, even including the one which I am reading, all copies are marked to different number 3 and 4. All emails are marked to different number 3 and 4. And I am going to deal with that point separately. But just I am pointing out since we are on this at present. Now, sir, what they say? They say your offer was never accepted by us. And you were one of the several bidders. Sir, if that was so, would PwC, in response to our offer of 9th September and 20th September, say that let us ask our lawyers to inter se work out the finalization of share purchase agreement? Would they say in the subsequent email to keep patience? Sir, for the first time, the email which I read where they committed a breach and conveyed to us, it is on 8th of November. Sorry, 13th of November, giving a press release and informing us that we are going ahead with other party. So till then, nowhere it was mentioned. Rather, we were called upon to carry out further exercise to see that everything is finalized by executing the share purchase agreement. And sir, again I am maintaining, share purchase agreement was consequence to the contract. It was not the contract. And this is what the trial court has said. And then after this, sir, we thought that now there is no response from them, a positive response. We ultimately filed the present suit, seeking specific performance of the contract, which, according to us, was arrived at on 20th September 2024, when our 9th September 2024 offer was accepted. And thereafter, the breach they committed on 13th of November. And in the alternative, we have paid for 9 million euro as break fee. Our first content prayer is for specific performance. Sir, we can always pray alternative relief, saying that if not specific performance, this much was agreed as quantification of our loss, they must pay. So this is how, in my respectful submission, the matter stands, and therefore the conclusion of the trial court. Sir, I am on the point. The conclusion of the trial court is a possible conclusion on the correspondence on the record. If it is a possible conclusion, it cannot be interfered with under Order 43, Rule 1, Subclause R of CPC in an appeal. Whether this conclusion is the right conclusion or not, whether other view is required to be accepted, replacing this conclusion cannot be looked into at this stage. This conclusion falls in the exclusive domain of the trial. As the Honorable Supreme Court has consistently ruled, and I took my lords in the first session, in the second session, from Vander's case to last Ramakant's case by the Supreme Court, where Supreme Court says, unless it is found to be perverse, and perversity means no man of reasonable prudence would ever reach to a conclusion. Now, what my learned friend is trying to contain, the contention of the appellant is, unless and until the share purchase agreement is executed, the transaction cannot be said to have been finalized. Our contention with the trial court has accepted is, share purchase agreement is nothing but a formality to follow the contract which was concluded. Therefore, the formality will not take a driver's seat merely because something which is consequential, sequel to the contract, is not done. You cannot say the contract was not arrived. Now, this is the possible view. I am not saying that at this stage, unless and until the evidence is laid, which view is the correct view can be finally held. But if the trial court has taken a view, I put it conversely, sir. If trial court was to take a view on appreciation of the documentary evidence, then no, I don't find a concluded contract. Sir, it would not have been possible for me to upset that particular finding by preferring an appeal from order. Sir, all these judgments would have come in my way as a stumbling block. So emphasis is on, sir, that what is arrived at by way of a finding of fact by the trial court is nothing but a possible view of the matter. And if that is the possible view, it cannot be termed as a perverse view so as to invoke the jurisdiction of this honorable court, and that too when the honorable court is considering the stay application. If something which cannot be looked into at the stage of filing of the appeal can definitely be not looked into when stay application is being considered pending final disposal of the appeal. Sir, with this, sir, I have to turn to another submission. Because this would go to indicate that view taken by the trial court is a possible view, and now the contention raised by the other side, and to which me in the first half a query was put by your honor, that what are we to answer on the jurisdiction part. Because it is the contention of the appellant that civil court, rather commercial court at Vapi, is not having a territorial jurisdiction to entertain the present suit because parties had agreed to restrict the jurisdiction to the courts at Germany. Now, sir, if the appellant is relying upon a provision which is there in phase 1 offer letter, because I pointed out that this Germany clause is there only in their invitation to us for an indicative offer. It is not there in their second phase offer to us, or invitation for the second phase offer to us. But sir, be that as it may, I will touch that aspect little late. The first point is it permissible for the appellant to raise the point of territorial jurisdiction in the present appeal from order, particularly when an application under Order 7 Rule 11 was moved before the trial court on the ground of trial court lacking the territorial jurisdiction on account of a clause in the concerned letter for phase 1 restricting the jurisdiction to the courts at Germany. So before I take your honor to the merits of this provision figuring in phase 1 later and what is its repercussion. સાહેબ આ ક્લોઝને કારણે આપ નામદારનું jurisdiction, rather વાપી કોર્ટનું jurisdiction આવી શકે કે નહીં એ મુદ્દા પર સાહેબ આગવું એ પહેલા મહત્વનો મુદ્દો એ છે કે આ પોઈન્ટ, આ કન્ટેન્શન એપેલેન્ટ આ અપીલની અંદર લઈ શકે કે નહીં. સાહેબ મારી દ્રષ્ટિએ આ કન્ટેન્શન એપેલેન્ટનું આ અપીલમાં લઈ શકાય નહીં, કારણ કે it is barred by principle of res judicata and estoppel both. The reason is, sir, in the present suit, an application under Order 7 Rule 11 was moved by the present appellant defendant number 1 at Exhibit 27, page 595 of the paper. Your Honor may see the title of the application, page 595, Exhibit 27. Am I with Your Honor?
Seeking rejection of plaint as amended by the amendment application.
Application of the defendant seeking rejection of the plaint as amended by the application under Order 7 Rule. So our amended, after we moved an amendment, they move another application seeking rejection of our amended plaint under Order 7 Rule 11. Now, what was the ground on which the rejection was prayed for? The first ground, Your Honor would find on page 600. The courts of Frankfurt, in Germany, have the exclusive jurisdiction over the dispute raised by the plaintiff against the applicant. Then, sir, they are referring to in clause 13, paragraph 13. Process note 1 states as, so in later issued to us on 3rd June 2024, inviting us for an indicative offer, which I read with Your Honor, phase 1 later. That clause they are referring. And then they say, accordingly, once the plaintiff has agreed to the aforesaid term of process note 1, the present suit cannot be held to be maintainable before this honorable court and is liable to be dismissed. Then, sir, during the course of argument, I'm not reading the entire application because my purpose of referring to this application is to show that rejection of the plaint was sought on the ground that there is a provision in process letter 1 for phase 1 restricting the jurisdiction to the courts at Germany. During the course of the hearing before Your Honor, as also during the course of the hearing before the trial court, they also refer to the share purchase agreement, the draft of which was provided to us, stating that even that agreement is also having a provision for restricting the jurisdiction of the courts at Germany. And the courts in India will not have a jurisdiction to decide any dispute concerning the present transaction. And accordingly, based on that, rejection of the plaint was sought. Now the trial court, in respect of this application, sir, before that, on another point also, this was the rejection, that there is no cause against the defendants, to which I'll revert at the later stage. For the time being, I am only on the point of territorial jurisdiction. But let me complete the facts also, that it may not be said that I have not applied. On two grounds there for rejection of. One, territorial jurisdiction is not vested with the court in India. Jurisdiction of the courts in India is ousted. Courts in Germany will have a. And secondly, there is no cause against any of the defendants. That is what they have stated. Because they are not concerned with the transaction. Transaction is to be done by the shareholders of different number 1. For the time being, I am not on the second point. I am on the first point. The trial court, upon inter-parties hearing, on page 608 is the order, rejected their application, rather defendant number 1's application, appellant's application, under order 7 rule 11 clause D, on the issue of territorial jurisdiction. The trial court came to a conclusion that regardless of that particular clause, it would have a jurisdiction. Meaning by which the issue of territorial jurisdiction, which was raised by the appellant different number 1, by moving an application under order 7 rule 11, attained finality, because this order rejecting their order 7 rule 11 application has not been challenged till this date by the appellant different number 1. So the conclusion reached by the commercial court at Vapi on aspect of territorial jurisdiction, negativing and discarding the contention of the appellant different number 1, has reached finality. And therefore, it is no longer open for them to raise a contention in the present appeal that the commercial court at Vapi was lacking a territorial jurisdiction, and therefore it could not have passed the impugned judgment and order. Once you raise an issue in the proceedings of the suit, and once that issue is negated by the court, and once that decision is accepted by not preferring any appeal or a revision or any challenge in whatever way available, appeal may not be maintainable, so maybe a revision. Once you subscribe to that particular judge decision of the trial court or a commercial court, you cannot raise that point again in the same proceedings, and the present appeal would qualify as the same proceedings because it is arising out of a civil suit, continuous proceedings. They are barred by principle of res judicata and estoppel from raising this issue again in the present appeal. Sir, may I? Because I have to now cite judgments on this, which will take long. So, whenever Your Honor is keeping the matter, I would like to.
क्या रहा है सुपार कर भाई
I would like to
I'll-
prefer day after tomorrow, subject to the
No,
convenience.
sir. No, sir. Not day after tomorrow. It was agreed. It was on a day-to-day basis, sir.
Today's matter, I got it anyhow.
Sir, I agree with you. But then,
But
sir,
I'll leave it to the honorable court. If the honorable court says tomorrow, I'll accept it.
after 12:30 it is terminated.
No, instead of 12:30, sir, keep it 2:30, sir, tomorrow.
2:30 રાખો
2:30 સાહેબ રાખો કાલે. I'll somehow manage 2:30. 2:30, sir.
sir, you will finish by tomorrow. Then accordingly, we
I'm-
may plan.
I am most probably finishing.
હા કાલે થઈ જશે હવે તો almost he has done now.
Almost.
કાલે હવે આપણે
કાલે હું સાહેબ પતાવી દઈશ. કાલે I'll 2:30 to પતાવી દઈશ. Definitely.
Okay. Thank you, sir.
We are obliged for the patient hearing, sir.
okay.
Thank you, sir.
Tomorrow 2:30.
Tomorrow 2:30, sir.
Okay.
Or 2:45, sir, because your honor will be rising.
2:45.
2:45. 2:45. Sir, may we have the permission to leave,
Okay.
please?
सही मैटर बोलिए आप